This quote is the finding of the land acquisition officer while fixing the compensation by taking the classification of the land as per record as Part 2 and the rate with respect to other categories of land has been enumerated as above. But the learned trial court, while in spite of recording a finding that the classification has become irrelevant and flat rate should be fixed for all types of land, has enhanced the rate for the land involved in this case from TAR 3 to TAR 2, as the rate fixed for under TAR 2 category was 93,790 as per the report of District Land Acquisition Officer Exhibit A. This court is of the view that in spite of specific finding that average flat rate should be fixed for all types of land, instead of taking average of all the types of land right from Dhan 1 to Parti, the learned trial court has failed to do this exercise. If the average was to be taken for all types of land for the purposes of computation of compensation, then the average of all types of land was required to be considered, right from Dhan 1 to Parti. This is over and above the fact that though the sale deeds which were produced and exhibited on behalf of the appellants were of smaller area, but the value was quite high, and the learned court has refused to consider the same, although as per the judgment passed by the Honorable Supreme Court, the same would be just a negative factor. And when no other land was available of a comparable size, the same also could not have been completely ignored. The fact also remains that the sale deeds which were taken into consideration by the District Land Acquisition Officer and also produced by the claimant was relating to the period from 2001 to 2004, which was certainly 1 year prior to the notification under Section 4 of Land Acquisition Act. In view of the fact that average flat rate of land was to be taken into consideration, ignoring the classification, this court is of the view that the average flat rate of land would have come to, ये सबका average कितना आता है? बताइए। Exhibit A के हिसाब से नहीं पूछ रहे, जो क्लासिफिकेशन किए हैं उसके हिसाब से नहीं किए हैं। Have you calculated this?
Yes.
What is, how much is this?
I just calculated.
हाँ, calculate.
Last page and Lakshya noted it.
हाँ, तो वो नहीं exact figure नहीं है. 438 350 वाला.
Yes.
I calculated it.
Lakshya wanted calculation of this Hanuman Dhan.
Yes, yes, yes. Last time किए थे आपको याद?
It is 2412.23.
Yes. It will come to how much?
2412.23 per decimal. So acres it will come, just 2,41,020 at 200.
ये कितना आ रहा है पर एकड़?
Per acre आ जाएगा. Per acre it will come 2,41,223.
241.
Yes, sir.
ये क्या किए हैं? इसको सबको 7 से डिवाइड कर दिए हैं.
6 से डिवाइड.
7 है ना?
7 है.
7 से डिवाइड होगा. तो it is 210,112.
2. Yes, sir. No mistake.
ठीक है. 210,112. It will come to rupees. आपको दिया कितना है?
दिया है
97,000.
ठीक. It will come to rupees 2,10,112. कैलकुलेशन हम लोग चेक कर लेंगे. आप ही चेक कर.
जी.
2,110 2,10,11 per acre. This court also finds that this particular rate is based on the sale deeds relating to the period 2001 to 2004. The acquisition has taken place, the notification is of the year 2000. Therefore, in view of the judgment passed by the Honorable Supreme Court, and considering the developing nature of the land involved in this case, 15% on this amount is required to be added for the purposes of fixing the rate. इस पर 15% ऐड करेंगे तो कितना होगा? 210,112.
24,162.
कितना?
24,162.65 per day.
हाँ, दोनों का ऐड करके.
हाँ,
ठीक. This is 315,160. कितना हुआ आप बताएं? 24,000?
24,162.65.
This would be the amount. Calculation हम भी चेक करा लेंगे. सही है. And rest does not call for any. सुप्रीम कोर्ट का जजमेंट ही है कंपाउंडिंग पर, लेकिन 1 साल का है तो कंपाउंडिंग का कोई मतलब नहीं है. ज़्यादा साल का अगर गैप होता तो कंपाउंडिंग हो सकती है.
मतलब 15% इंटरेस्ट दिया है.
वो तो अलग है. ये तो आपका 15% हम लोग जोड़े हैं basic rate of that.
Basic.
Or the rest of the calculation will be done on the basis of this. This appeal is disposed of with aforesaid enhancement in the compensation. Office to prepare the decree.
Adjusting the amount already. Why I say in most of the cases.
कैसे पता चलेगा?
लक्ष्य वो है डिग्री में लोड डिग्री में लिखा हुआ है। अभी क्या कर दे रहे हो? वो आज का डेट तक पूरा कैलकुलेट करके जब पे किए मान लीजिए 19 या 2000 में वो अमाउंट को अभी डिडक्ट कर दे रहे हैं। सब में सीएमपी फाइल करते हैं। इस सब में ऑर्डर होता है।
नहीं समझा।
लक्ष्य क्या होता है? मान लीजिए कि पे द अमाउंट सपोज द कंपनसेशन एज पर द कैलकुलेशन इज पेड इन ईयर 2000 land was acquired in 1980 and the decree is modified by this one in 2025. Now what office does is they calculate the amount till 2025 and then make a deduction of the amount which was paid in 2000.
नहीं ऐसा
प्रॉपर होता है कि 2000 का कैलकुलेट करके डिडक्ट करके फिर रिमेनिंग अमाउंट को फर्दर
नहीं कैलकुलेशन जो होगा वो होगा जैसे मान लीजिए आपका रेट बढ़ गया, रेट बढ़ के आपका टोटल अमाउंट मान लीजिए 50 की जगह 100 रुपये, देन अंडर सच सर्कमस्टांसेस दे विल प्रिपेयर द डिक्री as if this was the amount which was payable.
So there is no dispute.
Then they will calculate.
In the meantime मान लीजिए 50 हम जमा कर दिए उसका 10 साल बाद तो 10 साल तक का पूरा कैलकुलेट करके 50 माइनस कर देंगे फिर बाकी का कैलकुलेट करेंगे। नहीं तो क्या होता अभी तक करेंगे तो 50 तो हम 10 साल पहले जमा किए उसका फिर इंटरेस्ट हम आज तक क्यों देंगे?
So they are able to do that.
They do it here, but in many cases also we are filing CMPs and getting it corrected again here also. Therefore I was saying that Lordship said that
आप हमको बताइए रिकॉर्ड से कब पेमेंट हुआ?
पेमेंट हुआ है 11/4/2008 अकॉर्डिंग टू काउंटर डेबिट।
काउंटर से थोड़ी चलेगा, रिकॉर्ड से चलेगा ना, अपने काउंटर से नहीं चलेगा।
Lordship पहले इनिशियली जब एक्वायर हुआ था तो 77,845 was paid by the collector.
ठीक है।
That date is not mentioned in the decree. यही वो गलती की पूरा कैलकुलेट करने के बाद की। And thereafter in 2008 we made a further amount payment of 6,990. But those details will be there with the office.
कहाँ से ऑफिस? आपके पास आप रिकॉर्ड जो है वही है, इसके अलावा कुछ नहीं हम लोग के पास।
उसमें भी होगा।
बताइए आप हमको, आप कैलकुलेशन हमको करके दीजिए।
ठीक है, मैं आज लंच में
आप कैलकुलेशन हमको करके दीजिए, देन वी विल सी हाउ दिस अमाउंट इज टू बी। आई अंडरस्टैंड भाई इंटरेस्ट जब तक का आपने पेमेंट कर दिया है उसके बियॉन्ड कैसे इंटरेस्ट
जो पैसा जब जमा होगा तब तक ही
जो आपका जमा हुआ होगा ना पैसा वो आपके इंटरेस्ट के कैलकुलेशन में जाएगा, नॉट अगेंस्ट द प्रिंसिपल अमाउंट।
उस मान लीजिए at one point of time मान लीजिए प्रिंसिपल एंड ये लेके 100 रुपया लॉटरी में अवार्डेड टुडे, एक वन पॉइंट ऑफ टाइम में इट कम्स टू 110 रुपीस, आई हैव पेड 70 रुपीस, तो आउटस्टैंडिंग तो 40 रुपीस ही रहेगा ना जिसमें फर्दर इंटरेस्ट कैलकुलेट होगा। तो प्रिंसिपल एंड दोनों में जाएगा, पहले इंटरेस्ट में जाएगा और जो बचेगा वो प्रिंसिपल में जाएगा।
I'll find it out from the
Lordship will direct the office to prepare the decree, whatever has been passed. If there is any error, then we'll come back to you.
हाँ, if there is any error you can come.
Final
वैसे हम डिक्री सेक्शन से जरा पूछिएगा, बुलाइएगा कि इस तरह के ऑर्डर्स में कैसे कैलकुलेशन है और लोगों को बोलिएगा इसका कैलकुलेशन करके। हाँ, let us understand. We don't want unnecessary CMP. The court is supposed to quantify the amount, right? If there is any problem in preparation of decree, then we have to see how it is to be done. I will let you know. लंच के बाद हम आपको बता देंगे उन लोगों का क्या फीडबैक है, किस तरह से वो लोग कैलकुलेशन करते हैं और अगर पेमेंट बीच में हो जाता है तो उसको किस तरह से डिडक्शन करते हैं। एंड दे कैन ऑल्सो प्रोवाइड मी अ सैम्पल कैलकुलेशन शीट ऑल्सो, देयर इज नो प्रॉब्लम। एक केस में हम लोगों ने ये किया था ना कैलकुलेशन, दिखाई तो इसमें उसी में जजमेंट का कॉपी है। कैलकुलेशन तो कायदे से ओपन एंडेड रहना ही नहीं चाहिए, अदरवाइज
One example. one case, the compensation amount was reduced by this honorable court in appeal. Till now the matter is pending. So naturally, we had deposited the entire awarded amount pursuant to an interim order of this court. We filed an application for refund. Decree has been prepared of an amount excess than what we have. We said that till that day we have already calculated the interest and deposited. They made the same mistake. Now we have to file an application for correction of decree, which is pending.
I'll ask them.
Yes, sir.
मैंने रिकॉर्ड उनके पास भेजी और उनको बोलिए कि कब कब पेमेंट हुआ है, रिकॉर्ड से पता चल रहा है कि नहीं हुआ, पूरा डेट बनाएंगे, ठीक है, और कैसे कैलकुलेशन होता है इसका, डेट अगर चाहिए होता है, डेट कॉम्पनसेशन का, चाहे डिप्टी सेक्शन से बुलाइए.
For finals for item 2, first April 43 or 2012.
Finally, Your Lordship, today I have been able to prepare the synopsis and written argument, whatever is required. I am filing it today. Only one thing I will pray that Your Lordship, if during the course of hearing it further,
Yes, that is always
then
there.
I have prepared. According to me, this is complete. Absolutely.
During the
We
course of
have
hearing-
not completed, Lordship. The reason is that since Lordship they have not responded to the rejoined IA, which is a very vital aspect,
You're
Lordship,
not
in this
filing.
case.
I am filing it today.
And unless and until
Where
we
is it?
go through that, Lordship, we are
But-
not able to
But Your
advance
Lordship,
our
only
argument.
during the course of hearing the order 41-27, my also and his also would be seen.
In Lordship, my entire argument is based on suppressio veri and suggestio falsi. What they have done.
I am filing it
Even
today.
the trial court
Agenda
itself,
has to be
Lordship,
considered
the,
by us also in the written submission.
that is my written argument, written submission, written statement also. In several paragraphs, Lordship, we have stated that they have taken the advantage of a document which is non-existent. And
I'll
therefore,
show from
1994,
your own
1994
document.
Supreme
only,
Court Lordship.
only allow me one thing. My learned friend, they both are relying on a report of the AJP which was submitted during a proceeding. Both of
See,
them are
the
relying.
point is that you have responded. They also right to respond.
Today itself I am filing. Your
Where
Lordship,
is it?
it is always better to have a better draft than to file it and then now I
Where
am
is it?
convinced
Where
that
is
it
it?
is. Today itself I am filing.
Sure, file it.
Your Lordship,
It is in the
only
process of filing.
this is a synopsis and I am filing it in the process. It is in the process. So may I pray that Your Lordship may take it up to 15.
You see,
At that time, I
Nothing will happen.
ये केस कब से चल रहा है? कब का है?
2012 में
अब इसको हम डे टू डे सुनेंगे जब तक आप लोग का मन नहीं भर जाए एजेंडे से. आपको कितना टाइम लगेगा?
Just after seeing that, Lordship, I can respond.
वो तो हम आज ही फाइल कर रहे हैं.
Lordship,
Honestly,
we see what-
that was very important. Therefore, इतना time लग गया और
This much of green sheets
We have
very
seen
heavy
that.
on me.
दूर से ही दिखाई
लेकिन
देता है
ऐसा
आपको.
कुछ नहीं है. Unnecessarily the matter has been blown out of proportion. That is all. Absolutely very clear. case.
Very clear.
And,
case,
and
Lordship.
I'll
Both are-
also say,
Yes.
I'll also say that I'll start by saying that initially they are claiming through Dattas. Dattas were the original tenure holders. These are facts which are undisputed. I'll just give a very.
I'll just Lordship pause. I'll just.
आपने भी written submission नहीं बनाया क्योंकि जवाब
हमारा तैयार है उसको. लेकिन जब तक उनका because that is my core of the submission. Now Lordship, the conduct of the plaintiffs. Now they are saying that Dattas are the main person, but they never implicated Dattas as party initially at the time of filing of the suit.
लेकिन
Why they were not implicated?
But ultimately
That shows the conduct
implicated
Lordship
in the
and
trial court itself.
coupled with Lordship the suppressio veri and suggestio falsi. the documents which
देखिए
they
आपका
are.
ये लैटिन वर्ड का मतलब हमको नहीं समझ
The-
में
एक लाइन, अब हम इनका एक लाइन का जवाब
अब
हम
मैं
दे रहे
हिंदी में
हैं।
बोला
इनका
करिए,
WS
इंग्लिश में
में
बोला करिए, लैटिन अब छोड़ दीजिए।
इनका
We don't need Latin words anymore. We have enough jurisprudence in India कि हमें
Yes,
कौन से
yes.
word को क्या
Yes,
बोले।
but
आपको
these
थोड़ा
things
ऐसा
have been
समझाइए।
have been
इनका
considered lordship
WS
with
मेरा
many
एक
honorable
लाइन मेरा
citizens.
जवाब है। इनका my whole blame is based on M forms, and in his written statement he does not even deny those
That has
issuance
been
of the
denied time and
Your
again
Lordship may see
in
the-
all the paragraphs. Yes, I can show it just now. In all the paragraphs
ठीक
we
है,
have
हम
denied.
देख लिया जाए अगर इनका
अभी हम
एक
paragraph
सेकंड
दे देते हैं।
देखेंगे।
I'm ready with the brief. Paragraph 16,
आपका
15,
केस ही
16,
रेडी
17.
नहीं है सुनने के लिए तो हम क्या कर सकते
अच्छा वही ये आज हम लोग को कॉपी सर्व कर दें नेक्स्ट
हैं। आप फाइल करिए देखिए।
आज हम फाइल
हाँ फाइल करिए, आप लेके आइए, फाइल करिए, उसके बाद आपको कितना टाइम लगेगा।
2 weeks lordship. We'll do it within that.
ये तो
Although I'm ready with the
this is
case,
only
but-
a rejoinder, he has already
Yes,
filed it.
yes.
So now for his rejoinder also, if he
It
says
is-
that it is too weak.
Anybody else wants to respond to
yes
this?
lordship here
You also need to respond.
yes because
You will respond in.
also same time whatever time you lordship have within that time
उसके बाद तो नया कहानी मत उसमें बताइएगा।
नया कहानी कुछ नहीं बताएंगे व्हाट ऑब्जेक्शन
हाँ जो ऑब्जेक्शन है बस उसी को रिस्पॉन्ड, ऐसा
कुछ
नहीं कि
नहीं।
उसमें एक नया कहानी शुरू कर दीजिए फिर
मेरे
ये बोले
हिसाब से
हमको एक
तो
जवाब दे।
at least Dattas are clearly being sponsored by SFP hospital, absolutely clear. From their own,
देखिए कोई
I'll
किसी का
show.
just a moment.
Absolutely.
It has
I'll
got
show.
no relevance
I'll
who is
show. I'll
sponsoring
show. I'll
anybody.
say that.
We will decide the
Not at all.
case
It is-
strictly
No,
on the
no.
basis of
Something
materials.
beyond the records now.
But I'll show from the
Sponsoring wrong,
recordings.
your lordship, the
Now,
records are
they filed a fresh interlocutory application in this Friday itself. Now they say that my execution case it may be dismissed. Absolutely strange.
उनका एग्जीक्यूशन केस से
Oh,
क्या हुआ?
he being a respondent, he is challenging. The decree was passed in my
नहीं, just a
favor.
moment.
yes lordship.
At the first appellate stage, there is only two things which are
If
possible.
we succeed,
Just please give me audience for half a minute.
yeah.
In the first appellate stage, there are only two things which can happen. Either the case will be decided on the basis of materials already on record, or the case will be also considering the additional evidences which has been placed on record. Whatever is the consequence of the final judgment has to be taken care of by the concerned court. That is the executing court. We will not bother about it. कि executing court किसका dismiss होना चाहिए. We will not bother about it. The executing court will take care of its own execution, and we are not going to bother about it.
Lordship, therefore today I am not pressing that IE. I was waiting for your lordship, the final hearing to end. Then I would have pointed out that this is our IE pending. Whatever lordship wants to observe on that, then let the executive court
We
take
will
care.
not enter into what executing court में you don't know नया कहानी शुरू होगा.
नहीं इनका अपील अलाउ होगा
अगर
तो
इनका right
decree तो
है
ऐसे
तो
ही set
खत्म हो
aside हो
जाता है.
जाए.
If we are able to convince your
Any
lordship that
one
So therefore, what kind of IA have you filed in connection with
IE we have
executing?
filed for two reasons. One, your lordships, that executing court, lordship, they are proceeded in the manner. Lordship,
We are not here. आपको वो फाइल करना, आप अपना अलग से रेट फाइल करिए.
ठीक है, हम आज का अभी at this stage we are not pressing. I lordship will
बताइए कौन सा IA नंबर?
IE may be kept pending.
I will not be kept pending.
4640.
Lordship, then your lordship will have to press and have to show your lordship the illegality committed.
What illegality? We are only concerned with the main appeal and the additional evidence
What
placed
I
on
was
record.
saying, if
We will not see what
if as a-
executing court is
Lordship, we do
doing.
not know what will happen, what is the fate of this appeal. We may succeed or they may succeed. Lordship, in the event we succeed, Lordship, we may seek some observation from you. Lordship, for
It's
that.
not your appeal. Please don't ask me. I will either uphold the judgment, or I will set aside the judgment, or I will modify the judgment.
Yes.
And the High Court will prepare a decree accordingly. Decree will stand modified. A simple सा बात है.
decree
इसके लिए
stands-
जो executing court चल रहा है उसका हम यहाँ पे कोई observation नहीं कर सकते.
नहीं, Lordship, तो होगा क्या? Suppose
Scope नहीं है. Show me the scope. Show me the scope. You
Yes,
place your
just
right.
one thing. Suppose the lordship on the basis of a decree which your lordship ultimately sets aside, lordship my position has been disturbed in execution of that decree. But
I will not say anything. You will have your remedies as per law.
Lordship will ultimately say that.
I will not say anything. I will not say a word about it. I will not say that the clock has to be put back and how it has to be put back. We do not know. Maybe fourth party rights are created in the meantime. We do not know.
The fourth party right
You
is
see,
being
we
hit by
have
section
we have
50.
excluded all other persons. We have deleted their names. We do not know what is going on the property.
No, the person
If
whose
there
name
is-
has been deleted, he has a separate story.
No. They might be having. We are not here. Show me some judgment by which I can just observe as to what if there is already an execution already done, what will be the consequences. I am not here to decide
That,
that.
Lordship, there
We
are
will
series
not
of
decide.
judgment which says, Your Lordship, that if ultimately the judgment is set aside, then all steps taken by the executing court in execution of a judgment which was set aside by
For
the
that,
Supreme
the
Court.
appellate court need not observe anything. We do not know what is exactly
Lordship will
happening.
indicate that my IA will be considered at the
No,
final hearing.
no, I will not consider it. I will hear it right away. Because only those IAs are to be considered at the time of final hearing which are relating to additional evidence. Your IA is not additional evidence. Why should we consider it? And then at the time of final judgment you will say that my IA has not been considered. I will not permit that. No, you press your IA. You press your IA. What
My
is your
IA
IA
is
about?
only for the reason, Your Lordship, that once the matter has been remanded back to Your Lordships, or subsequent to Your Lordships,
Lordship,
is
may
your
I,
idea?
may I submit?
4640.
4640. 4640.
Second last. Yes, what is it IA? And who has filed it?
May I submit?
This is being filed by the respondent.
Yes,
Yes,
respondent
Very
number
good.
129.
In appeal of the in the appeal filed by the appellants, you will file your IA seeking some relief from this court.
for the
Why
reason,
should
Your
we?
Lordship, that our position has been altered pursuant subsequent to Your Lordship disposal of the first appeal, which was by a judgment which has been set aside by the Honorable Supreme Court and matter has been remanded.
Yes.
Now, if there has been certain alteration of our position subsequent to a judgment of this Honorable Court, which was ultimately set aside by the appellate court, Your Lordships, then Your Lordship, naturally we need to be protected. But still, I say, Your Lordship, that as the matter is sub judice, Your Lordship is finally hearing the appeal. My IA may be considered and my rights. If I
No,
succeed, if I
will
don't
not.
succeed,
I will not keep this IA open
because the case is
because I am not going to decide what is happening in the executing court and what has happened in the
The
executing.
Lordship will dispose it of giving me a liberty to approach the executing court, Your Lordship. For the
Yes,
next
that liberty is always there.
under the
Whatever
Lordship-
has happened in the executing court, if something has happened arising out of some judgment and which has been ultimately set aside or whatever it
Yes,
is,
yes.
you will have your own rights in the executing court. We are not going to.
If your Lordship dismisses it on merit without
We
giving
will
me a
not
liberty-
dismiss it on it. We will say that it is not maintainable.
Yes, and Lordship says that we have a liberty.
You have a remedy.
We have a remedy in the.
You may avail your remedy as per law.
Yes, this was Your Lordship may say. This
That
was
should
Your
be
Lordship.
sufficient.
Yes,
This
section
is not
144 covers his grievances.
This is not maintainable.
Not maintainable. And 144, section 144 of CPC squarely covers his grievance.
What does it say?
It says that restitution. Now, if your decree has been executed and if it is subsequently altered or set aside, then the person who has been dispossessed or whatever has been done, he would be restored back in the same position as it
This
was
is what I
before.
wanted from Your Lordship at the time
Because-
of disposal of the appeal.
It is,
नहीं,
it can
अभी
only be done by.
अभी कर देते हैं ना इसके लिए इसको नहीं पेंडिंग रखेंगे
ठीक है, Your Lordship say.
देखिए IA
Lordship,
नंबर
then Lordship,
4640
There
of
will be one
20 आपको
difficulty,
क्या
Lordship. Since Lordship, again the matter has already been concluded there in the executing court. Now Lordship, if at all Lordship
It is still
it is
pending. Your Lordship has called for the records.
execution is pending.
Your
Dhol
Lordship has
Lagada
called for the
Bani, whatever I
records.
have seen from the records.
You see,
नहीं, एक
if
चीज है, Lordship
the
will put it in
decree
his
has been
mouth.
executed, if the decree has been executed, then under such circumstances the parties may have their own remedies as per law. We are not here to advise them, or nor we are here to decide as to in what manner the execution, the restitution has to be done so far as the
Restitution
execution.
has to be done, Lordship, but when the
Not in the first appellate.
no, not in the first, but observations will be there, Lordship.
It
Since
will no observation will be there. I will simply say that he has objected, and I will say that this is not. They
Lordship
have
said that he has objected citing
Yes.
144.
Yes, not,
Yes, he has
not
objected.
maintainable. I say
He
that
has
as per
objected.
it is
144.
absolutely separate remedy which
He
he
has
has.
objected by citing 144
Yes, yes,
CPC,
so that he does
and
not-
I will say that this relief is not maintainable in this first appeal, and
Yes.
they may have their remedies as per
And
law.
if it is ultimately varied or set aside, that is the word used.
Hmm.
Varied, reverse, in appeal. So if your Lordship reverses or varies, then everything will be
We
done by
follow
you.
accordingly, we
Absolutely.
follow.
That is it.
We protect you. आप ऐसा को प्रीजज मत करिए, कोई भी चीज को प्रीजज मत करिए, चीजों को सिंपल रहने दीजिए और कॉम्प्लिकेट मत करिए.
जी Lord Ship. मेरा रेमेडी ओपन रहेगा so long as
आपका remedy open, always. IA number 4640 of 2025 in FE number 43 of 2012. This interlocutory application has been filed on behalf of respondent number 10 to 15 by citing section 151 of CPC with a prayer to set aside the execution proceedings made in execution case number 30 of 2023. The learned counsel has submitted that the matter has, the first appeal was earlier disposed of and the matter has been remanded by the Honorable Supreme Court for fresh consideration. And in the meantime, certain developments has taken place. The learned counsel appearing on behalf of the co-respondent, you are the plaintiff?
they are the printing.
On behalf of the, you are the plaintiff?
Yes.
No, they are the plaintiff. We are the respondent number 3.
On behalf of the plaintiff who are co-respondent in the present case.
Yes, 1 to 9.
Respondent number representing respondent number 1 to 9 has opposed the prayer made through this interlocutory application on behalf of respondent number 10 to 15 by submitting that in case any decree is modified, then under such circumstances the parties have remedy under section 144 of CPC and the present appeal is confined to the judgment and decree passed by the learned court below.
Yes, and as on date, the decree still stands.
And as on date, he submits that the decree
Still
of the trial court
still.
still stands. He submits that the present petition is not meeting. After hearing the learned counsel for the parties and considering the nature of relief sought for through this interlocutory application, this court is of the view that the nature of relief sought for, this court is of the view that the petition is not maintainable before this court. However, it is observed that the respondent number, however, it is observed that parties may have their remedy as may be permissible under law.
उनका submission
And in
section
accordance
144 लिखा है.
If the decree is varied or reversible,
Section 144 का ही लिखा है,
oh,
so that they do
obviously,
not.
ठीक है.
The learned counsel for the plaintiff respondent in this case has further submitted that the remedy will crystallize if the decree is modified by this court in this appeal.
Modified or reversed.
Modified or reversed by this court. ठीक है? ये हो गया? और भी कोई आइए है?
नहीं.
और एक और आइए है?
Yes.
वो क्या
That's the
चीज़ है?
most important आई. That is what words.
किसका आइए है वो?
वो आई इन्हीं लोग का दोनों साइड से आई है.
और बाकी 3 आईए हैं एडिशनल एविडेंस के लिए।
That is the time of the hearing.
Additional evidence. हाँ. Let me just clarify.
बाकी सब में रिप्लाई हो गया एडिशनल एविडेंस का?
नहीं किया ये लोग.
एक तो
उसी का तो कर रहे हैं. सबका हो गया है. 2 जो आइए है, 1 yes file, appellant for additional evidence and 1 their predecessor.
How many additional evidence idea are there?
There are altogether 3. 1 is complete and 2, 1
For two
which we
lots
have
is there.
filed, 1 which we have filed. I am filing counter today.
दो इन्होंने फाइल किया.
नहीं, ये तो जो फाइल किए मतलब एक तो अभी जो 4640
ये
का
तो एडिशनल
हाँ,
एविडेंस नहीं है.
बस
मतलब
एडिशनल एविडेंस का एक ही
दो आइए,
फाइल.
एक मेरा है, एक appellant का.
एक का प्लीडिंग
आप
कंप्लीट
दोनों का फाइल कर रहे हैं.
हाँ, दोनों का फाइल.
वो दोनों आइए नंबर कौन सा है?
और 3662 of 2025
3662
of 25
25
and 3659 of 2020.
3662 आपका है.
नहीं 3662 not
हाँ.
10 to उनका है।
Appellants.
Appellant का.
Appellants.
और 3659 है
Respondent number 10 to 15.
10 to 15. प्लेंटिफ दोनों आइए का आज रिप्लाई फाइल. पक्का ना?
पक्का.
अदरवाइज वी विल नॉट एक्सेप्ट.
ठीक है.
Additional evidence का तुम्हारा
The learned counsel for the
तुम्हारा भी additional evidence है क्या?
plaintiff who are respondent number 1 to 9.
They also have filed one application.
Who have filed?
But the
Yes,
plaintiff-
We
plaintiff-
have
Plaintiff.
also, we have already filed 2 years back, 3 years back.
That is
आईडी
very
नंबर
important.
क्या है?
4184 of 2022.
लेकिन अभी काउंटर तो सिर्फ इसी का ना है.
नहीं, subject matter
That is also important.
जरा मुझे just minutes
तो उसका
audience
copy
2
भी
minutes. I'll just make
Whom are you representing?
bas 90. On
9.
No, what
He is claiming
what I'm claiming, let me. Don't take it from my mouth. But what I'm trying to say is, so there is reliance on M forms. They want additional evidence. They want to produce M forms. Now they have an additional evidence. They say the M forms are forged. So that additional evidence issue needs to be decided first, because it is about fraud. It's about fraud. If you lordship just go
my
through,
submission is
if
also
you
that.
lordship just go
I'll
through
start
the
argument
manner in
with
which
that only.
the manner in
The
which
Supreme Court has clearly said that all the additional evidences in the first appeal are to be considered at the time of final hearing. I may reject all the additional evidences.
that is what I'm
I
trying to
may
say.
reject all of them.
You may,
because-
lordship may, that is
because-
your lordship's discussion. I'm not on that. What I'm trying to say is that is very vital to before hearing of the appeal.
Take
Why
care.
I'm saying so? Because it is about manipulation of the court's proceedings. So there is already a matter pending before this Honorable High Court also with respect to that issue only. So I was saying if the TAMFORM issue, which is the basis
We
of
will
all
not take it separately. We have already passed an order that all the interlocutory applications will be taken up at the time of final.
that is what I'm saying.
That order is already there. आप तो फाइनल हियरिंग के लिए तैयारी नहीं है तो अब हम क्या ही कर सकते
मैं
हैं? ये आपका जो एडिशनल एविडेंस है, इसका रिप्लाई फाइल हो चुका है.
नहीं, इसका कॉपी भी मुझे नहीं मिला है. मुझे अगर कॉपी दे
ये तो 2022 का फाइल है. एक बार मैटर हियरिंग होके सुप्रीम कोर्ट से रिमांड हुआ एंड ही सेज बिफोर हिम अनदर एडवोकेट वाज ऑलरेडी अपीयरिंग.
तो बिफोर रिमांड यू है.
हाँ 22
हाँ,
में 22 में
22 का ये है.
रिमांड तो 24 में होगा.
आई विल फाइंड आउट.
22 का है.
ये तो 22 का है ये. एडिशनल एविडेंस है ना.
हाँ,
additional evidence है,
Additional
M form reduce करने के लिए.
नहीं, अगर prior to remand है, then you shall take them take a copy.
I'll give a copy, but because
So I was not knowing.
We have
मिस्टर दास, इस रिकॉर्ड में थोड़ा टाइम स्पेंड करिए. ये फ्लाई बाय केस की तरह नहीं हो पाएगा. फ्लाई बाय केस नहीं है ये, और हम इसको इस तरह से करेंगे नहीं.
नहीं, इसको day to day करके.
I have the entire order sheet, Your Lordship, I can supply it to him.
आई थिंक सुप्रीम कोर्ट के जजमेंट में भी इसका रेफरेंस आएगा.
Yeah, that was a Arsafi. The appellant was Arsafi. They had filed an IF for additional evidence. That has been considered.
ठीक है, anyways. आप लोग को जो भी करना है,
जी.
हम आपको एकदम स्ट्रिक्ट टाइमलाइन दे रहे हैं. एक्सटेंड नहीं करेंगे टाइमलाइन.
ठीक है. उसके पहले मुझे एक चीज कहना चाहते हैं. One thing, only one thing, Lordship. I will just be supplementing what Mr. Shalais is saying. What Lordship has been done in this case, the 3 documents which were already filed during the suit, Lordship, which were considered the M forms, although they have spoken about 5 M forms, 3 M forms they have produced before the trial. All those 3 M forms, Lordship, subsequently when the inquiry went on by the state government, Lordship, its concerned officer has found all the documents to be forged, not issued from the office concerned. Now, Lordship, what my submission is,
Not issued from the office concerned means.
The person issuing the
M form, Lordship, issued by the custodian is the circular officer, and they have come to a finding that these M forms have not been issued, and that is the basis of their entire case, except the execution
M
case,
form जो एग्जिबिट हुआ,
Lordship.
वो कहाँ से आया?
That is what we want. यही तो बताना चाह रहे हैं. ये जो
अगर M form जो एग्जिबिट हुआ,
वही उस-
प्रॉपर कस्टडी से नहीं आया,
नहीं आया
तो हम
ना.
ऐसे ही रिजेक्ट कर देंगे.
वही
उसमें.
चीज तो हम
यही
बोल रहे
तो-
हैं.
फिर उसमें क्या
And I
सोचना?
say, actually,
उसके लिए फोर्जरी बोलने का कोई
नहीं,
जरूरत नहीं.
and I say that Your
Because
Lordship,
these documents has to come from proper custody.
Subsequently, Lordship, when the inquiry went on, we were also not aware. Since Lordship, some document is certified copy is being produced. Now, those certified copies subsequently by the concerned officers, they come and say in a separate case, Lordship. They say that these documents, these original M forms, have not been issued from our office. They are forged and fabricated document, and that is the base of the entire case.
Original and form exhibit हुआ कि certified copy.
Certified copy, original तो है ही नहीं कहीं.
कैसे हुआ ये
Original is
बताओ?
nowhere.
कैसे हुआ ये बताओ?
बिना hearing का
किसी
this is
और
not
केस का
possible.
certified copy
I say-
निकाल के यहाँ
and
लगा
I say with
Let
respect.
us
नहीं
complete.
करेंगे।
एक
नहीं,
एक करके बोलने
and-
दीजिए ना.
and I say
Why
that
we try to
already-
verify?
Date proceed for hearing and then.
My client may be sent to jail and it is ultimately found.
No. Therefore, I am relying upon
And
the
FIR
judgment
also
of the
against you.
Supreme Court, which says that such kind of activity in the court cannot be tolerated.
इसी के लिए तो बोल
It
रहे
has to
हैं
be summarily rejected, and that print has to be rejected.
plaintiff को
That-
jail
that
भेज
is my
दिया जाए
argument.
if it is ultimately
That is
found.
my- I will initiate my argument from that point. And therefore, Lordship, those documents, those additional evidence are required to be considered prior to the coming to the judgment, Lordship. Only because it is a special case.
See how they have been prepared. I'll tell you. Now there is one proceeding wherein you put in one photocopy, and in that proceeding you put in one photocopy of the
Yes.
form. Thereafter, what you do is you procure the certified copy
Yes.
from that particular court and you produce it in the suit court. That was found.
Likewise, Lordship, if
So
this
this
is the
is the
IA,
law-
we obtain a
this is
certified
what
copy
the
of
law-
this
this is what
IA,
has been
which
done.
contains, Lordship, the photocopy of the M forms. It will be a certified copy of the particular document, and those documents has been produced in the trial court. This is how it has been done.
And your lordship,
And it has to be
only
minutely observed by
what
the
is
person.
his claim, through whom he is claiming, just your lordship may hear.
What?
Through whom he is claiming.
Is it required?
Mr. Sailesh is client is
suffered a
claiming
lot
through
because
whom?
of
The
He is
court has
claiming
to
through me, and he
because
said
of
this
this
my
conduct
word
he has
from
given.
the
Mr. Shailesh is appearing on
Absolutely.
behalf of power of attorney.
Strange.
He absolutely
Absolutely.
plaintiff, and now
And
he is
saying
getting
that-
thrown
क्या है?
against
Plaintiff
him.
अगर डूबेगा तो वो थोड़ी
वो
बचने
डूबेगा।
वाला है।
हम ही को
हम
डुबाने
लगेगा
लगेगा
तो ये भी
हम
जाएंगे, हम भी
वो
जाएंगे।
cannot
shut the eyes,
हम भी
not
जाएंगे।
shut. What cannot
Absolutely.
shut the
want
eyes?
Your
that.
lordship may see
I
only-
want that. I want that.
Yes,
I
yes.
want that.
Yes, yes.
That the,
I say that my
that the
client,
people who are
my client may be sent to
Yeah,
jail
ऐसा
if it
है।
is
Not the
ultimately
court.
found to be.
Action should be
ऐसा
taken
है,
against them.
whatever has been exhibited before the court, we'll have to find out as to whether it has been exhibited in accordance.
In accordance with correct.
That's it. अगर मान लीजिए कोई सर्टिफाइड कॉपी कहीं पे एग्जिबिट हो रहा है तो वेदर द सर्टिफाइड कॉपी इज द प्राइमरी एविडेंस or it is the secondary
Which is,
evidence,
your lordship-
and whether it could have been taken into consideration, not could have been taken into consideration, we will see.
But that all you will see at the
This
time of
is
hearing.
one part.
Now,
What Lordship is saying, this is the one part. The other part is forgery.
एक इन्हीं का
How they have
document-
tried to mislead the court and
हाँ,
get
चलिए।
benefit out of a document which is non-existent.
एक बार खाली
From that
your lordship may
part-
see-
आपका जो सर्कल ऑफिस है ना वो
हाँ।
कौन से डॉक्यूमेंट को नॉन एग्जिस्टेंट बता देगा ये कहना बहुत मुश्किल है।
Therefore, Lordship,
Therefore,
the state should come now.
therefore we do not know.
एक सिर्फ डॉक्यूमेंट देखा जा रहा, हम और कुछ नहीं बोलेंगे, just to satisfy judicial conscience. He has filed, my learned friend, 10 to 15, your lordship may take up that IA 3659. One document I'll show, his own document which he produces. What does he say? 3659, and he is annexing page 32, your lordship may see. He is annexing, he is relying on those documents. 3659.
Yes, page number.
Page number 32. This is a document on which my learned friend is seeking to rely and is producing by way of additional evidence. Your lordship may see, your lordship may allow me to read this. This is a point submitted on behalf of state through AGP on behalf pursuant to order dated so and so. Jama Bandi number 49 opened in the name of Ambika Balapur. He is giving the details. Now he says rent was fixed. Page 32, if your lordship would have.
Yes, yes, I'm there.
Yes. Rent was fixed, and rent is obviously fixed in a rent fixation case on the basis of which M form is issued. Rent was fixed of Moja so and so, Khata number so and so, and so and so. All these Khata numbers have been mentioned.
Let's see the sequence. Under the Bihar Land Reforms Act, the return is filed under form
Under form K,
K.
and then the
Follow
state.
state
Yes, the state issues M form.
M form,
Yes, based on the return submitted by the landlord,
which is final,
which is fine.
Which is fine.
which fixes the rent etc.
Yes, yes. What happens, your lordship?
Form K is not.
Under it is not there. I say that it is not. I have not yet filed. Now this is, Your Lordship may allow me to read
Yes, yes.
why it says, rent was fixed of Mauja so and so, Khata number so and so, total area 15.39 acres. This is important. Now each of the M forms which are there before Your Lordship, all these Khata numbers and area has been mentioned in those M. But in so and so, and then Your Lordship may see, but lot number, what was the objection of the state? That lot number, last three lines, 631 and 632 of Khata number so and so have been transferred by Sairat Panji, but these plots have been mentioned in Jamabandi number 49. This was the only objection of the state, that it was a Sairat, but that has been mentioned in the M form. So what the subsequent in this proceeding itself, in this proceeding before the Deputy Commissioner itself, he removed these two plots from our M form, although he could not have, but that is a separate matter. He removed it, and the same, we challenged this. When he removed this, we challenged this by filing a writ petition. Ultimately, we withdrew. So ultimately, whatever order has been passed by the Deputy Commissioner in this proceeding itself, that has attained finality. And then what it says, Your Lordship may then turn to next page. All these are persons who are descendants or the predecessor in interest of the present plaintiff. Jamabandi number 59 opened in the name of Ravindranath Paul. All these are plaintiffs.
आज जो यहाँ पे इस तरह से फोटोकॉपी लगा दिए हैं, you will have to produce whatever it is. ये फोटोकॉपी हम देखेंगे additional evidence में.
नहीं, लेकिन but I am also.
और पढ़ा भी नहीं जा रहा. I am not even
objecting.
able to read it.
Yes.
But once Your Lordship allows, then only we will lead the evidence.
No, I will need it simultaneously. What do you
So
mean?
we
At the time of hearing, I
will
want
decide
जिसका
that-
original नहीं produce करिएगा, उसको हम वैसे ही reject करेंगे.
ठीक, certified copy हम लोग रखेंगे. Your Lordship says we will file it in the.
You have to prepare a list and furnish it in the court. क्योंकि यहाँ पे एडिशनल एविडेंस आ रहा है बहुत सारा, इतना मोटा एडिशनल एविडेंस रहता है और अल्टीमेटली 3 डॉक्यूमेंट प्रोड्यूस होता है ओरिजिनल, बाकी सब डिस्कार्ड.
लिस्ट बना के Lordship will keep it ready.
No, it is
What is
requirement,
the
Lordship. All the certified copy is required to be filed along with the act.
Yes,
That is the requirement.
that is the
File
requirement.
the certified copy in the meantime. But I was under the
जो
impression
चीज
also
नहीं
Lordship
होगा
will-
नहीं, that is the law. It has to be filed along with it.
As it is.
And in this proceeding, Your Lordship,
And this is not very legible. नहीं, इसको इतना कैसे हम इतना फ्लो भी नहीं आएगा पढ़ने में. इसको थोड़ा सा टाइप कॉपी जो भी एक साथ में इसको फाइल करेंगे. आप भी कुछ फोटोकॉपी फाइल किए
No,
हैं?
no, हम सर.
आपका फोटोकॉपी है कि क्या है फाइल?
मेरा ओरिजिनल है और या ये
आइए में
certified
फोटोकॉपी है
वो
कैसे?
हम चेक
आप चेक कर लीजिए. जो चीज आप नहीं फाइल करिएगा ओरिजिनल वो हम नहीं देंगे. कम से कम इधर इट शुड बी
नहीं, हम
ओरिजिनल
check
और इट शुड बी सर्टिफाइड.
चेक कर लेंगे जो भी होगा.
You want to say that this form M was acted upon.
Absolutely.
That
And
this
Your
is what
Lordship-
you want to demonstrate.
Now, Your Lordship, one proceeding
Now
which was
nobody can say that
one
it is.
proceeding would absolutely make everything clear. The proceeding in which this particular point was submitted by the state pursuant to an inquiry when the remand order was made in a separate proceeding by this honorable court. What had happened that in pursuant to M form our names was entered in, obviously registered to all these Jamabandis which have been mentioned. They are in acres, separate Jamabandi numbers were given, and those Jamabandi registered to itself mentions a case number. That by this case number, this Jamabandi is being opened, and the Khata plot total area has been mentioned, and the person in whose name the Jamabandi has been opened has been mentioned. That those proceedings are strangely not in dispute. Now what happened? This was done sometime in the year during rent after vesting. This was 61-62. Then the Dattas during those compensation and all other proceeding under 5, 6 and 7, they had filed an objection claiming that certain plots were there also. The compensation officer very clearly rejects their claim on the ground that they have absolutely lost everything within that village. They have nothing subsisting in that village. Now that the Patna High Court judgment is there very clearly, which says that the proceeding under section 5, 6 and 7 of PLR Act is a judicial proceeding, and what the appeal is provided under section 8 of the PLR Act. So if no appeal has been finally if it is not altered in any appeal, then that attains final. So here also, all these compensation cases were initiated, and based on those proceedings, M-forms were issued. Based on the M-form, Jamabandi was opened. Separate Jamabandis of these five persons. Altogether there were 6 falls, but 1/6 Haribol Paul, his land is not involved in the instant proceeding. Now what had happened to his plot was that his plot was acquired by BCCL, and ultimately the state acquired for BCCL, and the matter went to the land acquisition judge. Land acquisition judge, that is also an exhibit. He decides all these matters, and because some of the persons were claiming through dattas on the basis of the sale deeds executed by them, then therefore the disputes had went up to the land acquisition judge. He decides the matter again, saying that dattas have absolutely no right, and therefore they did not have any bendable right which they could have transferred it to the purchasers, and therefore that is also very important. Now, most important document would be ultimately the report which was submitted by the AGP in this proceeding, that is miscellaneous case 5 of 2008,
What was the M-form did you
which we had. There were 5
file?
M-forms.
Certified copies.
Uh,
You filed certified copies.
certified copies of the 3 M-forms which were already there before in the land reference case, which was the originals were there in the land reference case, and the certified copy, because that trial was still going on, then we took out a certified copy and we produced it in this particular proceeding. So they were properly exhibited in that proceeding itself, and based thereon already an order was passed, and 2 M-forms are there. By mistake, what had happened that Haribol Pauls, whose land is not involved, his M-form was filed in this case. Altogether 4 M-forms were filed. 3 were related to obviously the person. They had already filed. 4th was of Haribol Paul. His land was not involved. Therefore, when the during
What additional evidence have you filed?
yes, 2 additional M-forms which were not filed before the trial.
Are they required?
It is not required because, Your Lordship, the Deputy Commissioner's order, I'll show from all, therefore time and again I am repeating that from all other documents I'll show, I have to only connect. I have to connect the dots.
If there is a document
Yes.
and there is a cloud on that document, and if anybody is able to show that the authorities have acted upon
Absolutely.
that document in a particular manner and acknowledge the right of one or the other party, so therefore that backup document stands
Absolutely.
fortified.
That
This is
why-
what you want to say.
Absolutely, yes, absolutely.
Even if your
Therefore-
M-form is under cloud.
Therefore, from the day one, I am saying that Your Lordship may hear, and then I'll connect the dots. I'll show that initially the property belonged to Dattas. Absolutely no doubt.
So whatever M-form you have filed,
Yes,
you have to show with respect to this particular property as to how this property has been dealt with by all other authorities, acknowledging what is there in your document.
exactly.
If you are able to demonstrate that,
I'll demonstrate. I'll demonstrate, and one order passed by the Deputy Commissioner, which was challenged by us because he had taken out 3 plots from my M-form. So we are challenged, we withdrew that, saying that, so therefore that order is absolutely, it would make everything clear. If Your
that is
Lordship-
exhibit.
That is exhibit, Your Lordship.
It is exhibited.
Yes, exhibited.
It is not in additional evidence.
It is exhibited, already it was exhibited.
Okay, we shall see. With respect to Likhito, IA number 3662 of 25 has been filed by appellant, and IA number 3659 of 25 has been filed by respondent number 10 to 15. And IA number 4182 of 22 has been filed by the
4184. 4184 of 2020.
4184.
Yes.
The 4184 of 2022 has been filed by respondent number 129, the plaintiffs of the case. All these interlocutory applications are for filing, for adducing additional evidence. The learned counsel for the respondent number 129, the plaintiffs, is permitted to file reply to IA number 3662 of 25 and 3659 of 25 during the course of the day, failing which no further opportunity will be granted. It appears that IA number 4184 of 2022 filed by the respondent number 1 to 9 has not been responded to by the appellants. आपने respond कर दिया?
Yes, yes.
By the respondent number
10 to 15.
10 to 15. They are permitted to respond to the interlocutory application within a period of 15 days from today, failing which no further opportunity will be granted. The rejoinder to the reply which is being filed by the respondent number 1 to 9 during the course of the day be filed by the respective parties within a period of 15 days. Rejoinder to the counter affidavit to 4182 of 2022 be filed by the respondent number 1 to 9 by and stroke or by the appellant within a period of 1 week thereafter. आपका 15 दिन, आप एक हफ्ता में उसके बाद रिस्पॉन्स पाइए. करेक्ट? आपके
मेरा सिर्फ आज की जगह कल कर दिया. Is permitted to file till
by tomorrow.
By
डेट बताइए.
तो वेकेशन के बाद में रखा गया. देख रहे हैं डेट चला जा रहा है. मेन
इधर ही
8-9 तारीख को चला.
नहीं, वेकेशन के बाद नहीं रखेंगे.
उधर 8 तो ऐसे ही चला जा रहा है.
कोई बात.
6 तारीख तो ऐसे ही चला जा रहा
और 5th को रखा जाए, 5th में कंटिन्यू.
नहीं, 5th कैसे होगा?
नहीं,
तो
ऐसा
15 दिन तो
है,
नहीं.
हम रखेंगे छुट्टी के पहले एक दिन, उसके बाद जब क्लियर हो जाएगा कि सब कुछ कंप्लीट हो चुका है,
हाँ,
तब वेकेशन के बाद.
तब ठीक है.
हियरिंग तो वेकेशन के पहले नहीं हो पाएगा.
6 तारीख तो हुजूर टाइम ही दे रही है, तो 7 को रख दिए.
ठीक है. Post this case on 7th.
Not sure.
आप अपना दे दीजिए.
notes also please.
You see, just a moment. आप हमको ये दे दीजिए, just a moment.
दे दें.
The manner of submission of written submission.
Pen
is-
drive.
Pen drive, I will take it. That you have to exchange it amongst yourself
Yes.
simultaneously.
Yes.
ऐसा नहीं है कि
Lordship
written
is-
notes का एक
last
response
occasion
कोई फाइल
Lordship is-
करे.
अच्छा ठीक है.
ऐसा नहीं होता है.
ठीक है. ठीक है.
इसीलिए
तो हम थोड़ा देर
हाँ,
हम आज ही
आराम
देते
से
हैं.
हम
आज ही. आज
ये
ही
दे
देते
देंगे.
हैं. हम बेटर.
ठीक है ना, आप लोग आपस में एक्सचेंज
हाँ,
करके
ठीक.
इसको.
At least facts should be common.
ठीक ठीक.
More or less.
एक बार हम करा लेते हैं.
आप अपना देख के समझ के दे
हाँ,
दीजिए. एंड कोई ऐसा कुछ नहीं होता है हियरिंग के समय. अच्छा, इट इज फर्दर ऑब्जर्व दैट if one or the other document has not been filed in original along with the interlocutory application, the same be also furnished prior to the next date of hearing, failing which the document will not be taken into consideration. आप फाइल कर देंगे इसे.
There are two orders filed by Deputy Commissioner. The first order I am referring, which was miscellaneous case 524.
उनका जो आईए था वो डिसमिस एज नॉट मेंटेनेबल होगा या डिस्पोज.
Dismiss was not.
Item 3 for WPC 5781 of 2016, along with item 4 to 6.
आज 215 में कुछ रखे हैं क्या? आज 215 में कुछ है क्या? 215 में आ जाए.
हाँ ठीक.
आज हम कोर्ट में लिखाएंगे.
हाँ हाँ ठीक है.
क्योंकि अब सीएबी करने का कोई
ठीक ठीक
पर्पस
ठीक.
Item 7, second appeal 258 of 2019.
Who will argue? Has anybody entered appearance? Has anybody entered appearance for the respondent? देखिए तो respondent की तरफ से क्या appear करते हैं. देखिए second appeal number 258 of 2019. Counsel for the appellant is present. In spite of notice and grant of opportunity, nobody has entered appearance on behalf of the respondents. The records have already been received. Let this matter be listed for क्या matter है इसका? Specific performance. You are the plaintiff. Execution is going on. Yes. No idea. Delay has been condoned. आइए देखिए तो कोई पेंडिंग तो नहीं है. Let this matter be. Mr. Sani,
Yes.
we had given one more chance to the respondents to appear. They have not appeared.
Yes,
करना कब है ये बताइए. Execution चल रहा है इसका.
एग्जीक्यूशन तो नहीं चल रहा था उसमें, इसलिए शायद कुछ चांस नहीं दे रहा है. तो मुझे एक अपॉर्चुनिटी और
एक बस by way of
लास्ट
last.
अपॉर्चुनिटी
कब रख दे बताइए छुट्टी
वेकेशन
बाद.
के बाद.
Post this case under the heading for final disposal on 11th of June. Execution कैसे नहीं चल रहा?
नहीं किया, चल रहा था ट्रायल कोर्ट में.
आप किए ही नहीं.
हम लोग तो हार
अच्छा आप
गए.
डिपेंडेंट हैं.
हाँ, तो वो लोग करें
वो लोग नहीं किए हैं.
नहीं किए.
स्पेसिफिक परफॉर्मेंस मिलने के बाद भी नहीं किए हैं. बड़ा आश्चर्य का बात है.
लगता है इंटरेस्ट में जो भी हो एक चांस और दे दिया.
ठीक.
Item 8, second appeal 40 of 2022.
कल भी वो कल्पना मिला गेम फाइल करने को 1 और 2
1 and 2 की तरफ से.
Yes.
You are for appellant. You were seeking adverse position.
The one of the more grounds for the contention the plaintiff was adverse position for personal property because of the exhibits and the orders of the high courts. For that reason this was sent.
How many respondents are there? 2 respondents.
1 and 2
No, we are contesting response and the other is state.
Other is state.
Yes,
So we
well,
don't need
because-
to worry. You are for the state. वकालतनामा आखिर आपको मिल गया.
आज मिला है आज अभी फाइल करने के लिए दिए हैं इसमें
देखिए सेकेंड अपील नंबर 40 of 2020. Counsel for the appellant is present. Mr. Namatai
Om Prakash.
Om Prakash Singh undertakes to file wakalatnama on behalf of respondent number 1 and 2 during the course of the day. Counsel for the state representing respondent number 3 to 5 is present. At the request of the counsel representing respondent number 1 and 2, the matter is adjourned and is directed to be posted for final disposal on
Vacation के बाद
what the इस साल कौन सा साल है? इसी साल
इसी साल
और यही वेकेशन
मई में
हम सोचो दुर्गा पूजा वेकेशन 11th of June 2025. It is made clear that no further adjournment will be granted. उस दिन टाइम मत मांगिए 11 जून नहीं खुल रहा है क्या आपका कोर्स?
ना लेकिन
हम तो खुल रहे हैं।
इसमें आगे मेमो का कॉपी देने
आपके पास नोटिस नहीं गया?
नहीं नोटिस सेक्रेटरी क्या मेमो ये क्या हुआ स्लिप क्या हुआ मेमो नहीं गया
एडमिट होने के बाद क्या होगा ना? प्रोवाइड मेमो।
Item 9 second bill 190 of 2022.
Yes. 2 week time. देखिए सेकेंड अपील नंबर 190 और 2022 इसमें कोई अपील हुआ? One to 5 appeal, 6 and 7 नहीं appeal. The records reveal that the notice has been counsel for the appellant is present. He seeks adjournment. The records reveal that respondent number 1 to 5 has appeared by filing wakalatnama, but nobody has entered appearance on behalf of respondent number 6 and 7 in spite of valid service of notice. Respondent number 6 and 7 are sisters of respondent number 1 to 5. Let this matter be adjourned and is directed to be this matter is adjourned and is directed to be posted for final disposal on बताइए आप है respondent number 1 to 5 की तरफ
Yes.
से 6 and 7 आपसे बात नहीं कर रहे हैं आपके सिस्टर है
वेरीफाई करवा लेते हैं
on 11 June. तीन केस फिक्स किए हैं 11 June. आज के तीनों केस
Item 10. First appeal 149 of 2023.
you have filed a response to us. You can start with your IE. Let us see what is the nature of, or you can start it in any manner.
Maybe should let us start with the case itself and later on the IS and the
Yes.
Even otherwise, if this is not on record and if it is taken on record, but the merit of the case without these documents may also be seen.
That's
the suit property is basically the land was allotted to one Dinanath Chakravarti, and it was allotted through TISCO by TISCO to this man, and he died on 5/2/1982.
Just a minute. Tisco allotted.
Yes, TISCO allotted.
Suit property to Dinanath.
The claim is with respect to the superstructure above that land, but not with
Dinanath Chakravarti.
Ji.
Land was allocated.
Land.
Then he constructed some.
Some construction was made over the land, and the claim is for with respect to the construction over the land.
When did he die?
On 5th of February 1982.
1982. How this construction can be severed from the land?
Leadership, because the land that belongs to TISCO. At best, on lease, it must have been allotted to Dinanath, not the right title and interest owner. Thereafter, he constructed the building over it, and then with respect to the building, not the land. Land would not be transferred. Right title and interest over the land would not be transferred to anybody. But power of attorney was given to the respondent here, Sanjay Kumar Badani, by the descendants of Dinanath Chakravarti. Over the further structure.
Let us see the plate. Read the plate.
Yes. Above that, suit for specific performance of contract, recovery of possession, and temporary.
Read it quickly. Yes, please.
The one superstructure house at holding number 2 Surabaya area, South Park, Hospital area, measuring such more fully described in Schedule A within the jurisdiction of this court, it is subject matter of this suit, thereafter termed as suit property. The suit property standing on TISCO holding number 2 was originally allotted by MS Tata and Steel Company Limited in the name and favor of Dinanath Chakravarti. The said Dinanath Chakravarti died on 5/2/1982 and whose wife Raj Lakshmi Devi died on 1975, leaving behind 6 sons and 3 daughters. This such and such, such and such, such and such. Para 4. So there were 6 sons here and 3 daughters. The aforesaid 3 daughters, namely Srimati Shanti Bakshi, Somna Bakshi, and Shipra Lahiri, have executed and registered a deed of relinquishment by deed number such and such, 7/3 dated 7/3/1998, registered at sub-registry office at Jamshedpur, relinquishing their rights, claims, interest, and title over the TISCO holding number 2 in favor of their 6 brothers, Ms. Jitendranath Chakravarti and so on. Para 5. That the said holding number 2, after the said deed of relinquishment, was mutated and recorded by MS Tata Iron and Steel Company Limited in names of Jitendranath Chakravarti, Ravindra Chakravarti, all the brothers' name, as sub-lessee, by deleting the name of the original allottee, Dinanath Chakravarti, in its place from the company's record by TAL 2691 on 18th June 1998. That the eldest son of Dinanath Chakravarti, namely Jitendranath Chakravarti, mentioned above in para 3, died on 21/3/2001, and his wife Ashima Chakravarti was predeceased who died on 26/12/1984 and both died issuance and intestate. So their share in TISCO holding number 2 devolved to the legal heirs and survivors and brothers of the deceased equally. That the fourth son of late Dinanath Chaudhary, namely Suchendranath Chaudhary, mentioned above in para 3, also died on 3/1/2004, leaving behind his widow, Mrs. Rita Chaudhary, as his legal heir and survivor, being the co-share of the sole property. That the youngest son of late Dinanath Chaudhary, namely Ahindra Nath Chaudhary, also mentioned above in para 3, presently resides in flat number such and such Rajendra Lal Mishra Road, Kolkata 708. And is now settled abroad, and his brother Viren Nath Chaudhary residing at flat number such and such at Kolkata.
Para 9 is relevant.
Parallel.
So this genealogy is not in dispute.
Genealogy is
And this power of attorney is also not in dispute.
not at all in dispute. Rather, it is admitted by him that it was no problem. That the Ravi Nath Chaudhary, Viren Nath Chaudhary, and Mahendra Nath Chaudhary, all sons of Ledina and Lita Chaudhary, wife of Suchendra Nath Chaudhary, have executed general power of attorney in favor of defendant Suraj Kumar Badani in order to sell their share of the sole property. Only thing that is what has the contention has been raised by the defendant, the respondent, is that the genealogy, or I had no acquaintance with them, the persons who have entrusted the power of attorney to the defendant. So he has taken a plea that I have come to know from Savada because I have taken a plea that he himself showed me the details of the genealogy and how the property.
Genealogy is not in dispute.
Genealogy is not in dispute. How it came to my knowledge, that has been disputed by him.
It doesn't make any difference if the genealogy is not in dispute otherwise.
No, it does make a difference, my lord, to the extent because I have said that at the time of executing this, he showed me, I came into the knowledge that this was the genealogy and this is how the property has traversed to him.
Who is he?
He is the power of attorney holder.
He is fighting with whom?
He is fighting with me because he says.
Who are you?
I am the one power of attorney holder has executed an agreement with me for selling of the superstructure over the land.
Okay.
And I had paid him certain amount, and thereafter he denied to execute the sale deed, registered sale deed in my name, and then I approached him.
And these persons are alive, all of them.
He might be in a position to see.
Not all means.
Admittedly,
Where have you stated?
it has been stated in plenty itself.
What he has shown me, what is there in the plate, beyond that I have no knowledge, because that is based upon the documents provided.
No, I just want to know that altogether how many persons executed the power of attorney?
5.
No. Ravindra Chakravarti, Virendra Nath Chakravarti, and
Leela.
Ahindra Nath Chakravarti, and Leela.
Leela Chakravarti.
And
Wife
Leela.
of Sachindranath
Yes.
Chakravarti.
4 people, so 4
Four people. All of them are alive.
Nine.
That the said general power of attorney with respect to the suit property executed by Ravindra Nath Chakravarti, Viren Nath Chakravarti, and Mrs. Rita Chakravarti, wife of Judge Sachindranath Nath Chakravarti, in favor of defendant were registered in the office of Kolkata Registrar of Assurance such and such on 4th October 2004, and one general power of attorney by Ahindra Nath Chakravarti in favor of defendant was executed before the solicitor and notary public court such and such on 4th October 2004. That it is stated that the original copy of said general power of attorney was retained by the defendant in his custody and its copies was handed over to the defendant to plaintiff as a reference in regard to the suit property. It is further submitted that Ravindra Nath Chakravarti, Viren Nath Chakravarti, Srimati Leela Chakravarti, wife of late Sachindranath Chakravarti, and Ahindra Nath Chakravarti have executed the said general power of attorney individually in favor of defendant with respect to their conflict share of the suit property, leaving the share of Ranendra Nath Chakravarti in not out of the total area of Visco holding number 2. That the defendant on the basis of the said general power of attorney approached the plaintiff and proposed to sell the suit property, and the plaintiff, being well known to the defendant, accepted the said proposal and agreed to purchase the suit property from the defendant way of an agreement for sale on a total consideration amount of rupees 40 lakhs, only being the highest market price as fixed between the plaintiff and the defendant. That the said agreement for sale was given a final
This was
shape.
for the entire property.
40 lakh was for the entire property.
450.
4
There were 5 sellers, out of which 150.
The power of attorney holder was holding
Power for all of them.
Not only 450. There were 5 sellers, out of which one Ranendranath Chatterjee was left out of his share of 150 property. So only the property which was claimed to be agreed to be sold is 4/5 of the entire property.
Yes,
Correct?
Yes. Only being the highest one. The said agreement for sale was given a final shape on 1/6/2007, and the mutual offer and acceptance of contract by and between the parties was reduced in the form of written memorandum of agreement for sale on 1/6/2007, which was duly typed and signed by the parties in the presence of witnesses, and by which the parties inter alia agreed as follows: A. The defendant, in pursuance to the said agreement for sale dated 1/6/2007, received a sum of rupees 9,75,000 from the plaintiff as an advance amount, and the receipt of which was duly acknowledged and admitted by the defendant in the said agreement, as well as by granting money receipt to the plaintiff, which was duly typed and signed by the defendant in the presence of witnesses. The defendant further agreed and proposed to execute the registered and register a final deed of sale in regards to the suit property in favor of the plaintiff within 30 days from the date of the said agreement on the receipt of remaining balance of rupees 30,25,000 from the plaintiff. The defendant further agreed that if he fails or neglect to execute and register the deed of the sale in regard to the suit property in favor of the plaintiff within or up to the aforesaid stipulated period, the plaintiff will be at liberty to enforce specific performance of agreement by institution of legal proceeding, and in the event the defendant shall be liable to pay the cost and expenses of proceeding for specific performance to the plaintiff. That in accordance with the set terms of agreement dated 1/6/2007, the plaintiff on good faith paid the advance amount of rupees 9,75,000 to the defendant with respect to the suit property as part performance of contract, and which was duly acknowledged and admitted by the defendant in the terms of agreement, granting money receipt on the same day in the presence of the witnesses. That the plaintiff never doubted the bona fide of the defendant in abiding the terms of the said agreement in question, as a good relation existing between the parties, and accordingly the plaintiff waited for the stipulated period 30 days, but after expiry of the said stipulated period, the plaintiff approached the defendant and requested several times for execution and registration of the deed of sale of the suit property in favor of the plaintiff on receipt of the balance amount of rupees 30,25,000 by the defendant on or from 7/7/2007, started avoiding to accept the balance amount of rupees 30,25,000 only from the plaintiff, and refusing to execute and register a regular deed of sale in favor of the plaintiff in spite of the repeated demand of the plaintiff. Although the plaintiff was all along ready and willing to perform his part of contract arising out of the said agreement dated 1/6/2007, and in accordance to the terms of the said agreement, he has also performed a considerable part of it. That the plaintiff thereafter served a registered legal notice upon the defendant, requesting him to perform his obligation by executing sale deed of the suit property in favor of the plaintiff, receipt of the balance consideration amount through his lawyer by notice dated 27/8/2007. But the defendant, having deliberately avoided to perform this part of contract, has this suit for relief sought stated herein below. That under the fact and circumstances aforesaid, it is now required to enforce the terms of the said agreement and allow plaintiff to deposit a balance amount of rupees 30,25,000 only in favor of the defendant, and take possession of the suit property after getting registration and execution of the deed of sale in favor with regard to the suit property. The plaintiff submits that the suit property is kept locked with keys of the front room being kept with a caretaker for looking after the house, as because the co-share of the suit property may be Ravindranath Chakravarti, Virendranath Chakravarti, Linda Chakravarti, Vaisa and Arindranath Chakravarti have not been living in the suit premises. It is further submitted that the caretaker informed the plaintiff over the telephone that the suit property is lying vacant, and on evening of 10/11/2007, Mr. Suraj Kumar Madani, the defendant, came with 3-4 persons to the suit premises and threatened the caretaker to leave the suit premises with dire consequences because the defendant has purchased the suit property with all structures standing thereon and will dispose the same. The caretaker then left the suit premises. In the light of the developments set out above, it has become necessary to protect from alienation that pending hearing and disposal of the above suit. It is also necessary that the defendant, his agent, and or may be restrained by a temporary injunction from alienating, selling, transferring the suit property or party with other parts thereof. The cause of action for this suit arose against the defendant within the jurisdiction of this court from 6/1/2007, and the plaintiff and the defendant entered into the written agreement of sale of the superstructure of the suit property, and also on from 7/7/2007, when the defendant started avoiding to accept the balance consideration amount of rupees 30,25,000 only from the plaintiff and refusing to execute registered and regular deed of sale of the suit property in favor of the plaintiff in spite of repeated demands of the plaintiff, although the plaintiff is ready and willing to perform his part of contract in accordance with the terms of the agreement. For the purpose of the court fee, the jurisdiction of the suit is 40 lakhs. By the plaintiff, therefore,
My last line of all the pages of the plaint is missing, so I will need your copy. Right? My last line is missing, the photocopy that I have received. I need your copy. I'll take it from you later. I have read the plaint. What was your case in the written statement? Let him place his written statement. We'll find out the bone of contention between the parties.
Maybe.
Apart from the technical plea of readiness and willingness, was there any other plea?
Well, the agreement signature on the agreement was denied by the defendant. He denied that he did not. He received any legal notice dated 2007 manner.
The receipt of the amount is acknowledged.
Nothing.
9,70,000.
It has stated additionally that the property is sold prior to the execution of the purported agreement dated 1/6/2007.
Registered deed.
Registered deed.
that has never been brought up.
But deed number has been mentioned, date has been mentioned, and I will stay in possession of a copy of the sale deed.
No, that.
But that has not, no amendment has been sought for despite specific pleading in the WS by the.
They will not seek any amendment because it was sold prior to the agreement.
Man.
So they will not seek any
Well,
amendment
if,
to
the
that.
property is sold prior to the execution of the
Who
agreement.
was to prove that?
My burden was on the
No,
plaintiff.
who was the
Plaintiff
proof?
has to stand on its own leg.
That's right. Who has to prove that it was already sold?
Maybe it has not been denied that it has not
Who will
been
deny it? After the written
In
statement, there is
evidence,
no rejoinder.
in evidence it has
Who will? You have to prove that it has been
Well, I
sold.
have only in my evidence I have given the deed number.
That is not sufficient.
But the fact
That is no evidence. If it has to be brought on record by virtue of you do not know what is the
bare
nature.
reading of the one of the paragraphs of the plaintiff.
Anyways, let me see your written statement.
But I
So
just-
you have denied the agreement also.
My,
It's a forged document.
Well, before I start reading the WS, I would like to read one paragraph of the plaintiff matter,
Yes.
wherein it has been stated that the copy of it is a paragraph 10 matter, that sub-para 10. It is stated that the original copy of the said general power of attorney was retained by the defendant in his custody, and its copies was handed over by the defendant to plaintiff. For reference, it has been handed over. So there is no pleading to the effect that it was taken back. And furthermore,
No, which paragraph?
para 10, the first subparagraph. It is stated that the original copy of the said general power of attorney was retained by the defendant in his custody, and its copies was handed over by the defendant to plaintiff as reference
Yes.
in regard to the sold property.
So they could not produce it. This power of attorney is also not in dispute.
It has also not been produced.
No, may not be, but it is not in dispute.
It has
That
not
you are the
been-
power of attorney holder.
On the basis of which power of attorney I sold the property to someone else.
Maybe, We do not know. The point is that the fact that you are the power of attorney holder is not in dispute.
Not in dispute.
So they don't need to
Well,
prove
it has got some
admitted
relevance
fact.
from the point of judgment in which findings have been given with regard to this aspect.
Wrongly given, no. Admitted facts need not be proved.
Millard, only the date of registered sale deed has been mentioned in paragraph 19. So that
No,
means-
registered sale deed was
but that
required
has
to be
not been
proved.
mentioned.
Well,
Registered sale deed was required to be proved.
Deed number has also been mentioned.
It makes no difference. It is you who had to produce the
There
registered.
is one more aspect of the matter that wherein it has been alleged that the caretaker was thrown out, wherein further allegation has been leveled that
Yes,
there was
caretaker was
threatening
thrown out.
that can we see the last
This
three lines
allegation
of
has got no relevance.
para 17 of the claim. But it says that it is further submitted that the caretaker informed the plaintiff over telephone that the suit property is lying vacant, and on the evening of 10/11/2007, Mr. Suraj Kumar Badani, the defendant, came with 3 to 4% to the suit premises and threatened the caretaker to leave the suit premises with dire consequences.
Who had kept the caretaker?
But because the defendant had purchased the suit property, if there is a statement to this effect, then there will be a presumption that whether property is still lying with the defendant or not. And to that effect, there should be a relief. There should be a relief in the plaintiff itself.
Caretaker had said something. Somebody has purchased the property without any foundation.
No consequential relief has been sought for in the plaintiff.
What consequences?
There are 2 points that
Well, may I read my
Let me see his written statement.
it's nowhere he has averred with respect to readiness and willingness of mind, which I have stated twice in my thing. Not a single statement stating that I was not ready and willing to execute. Now,
It has to be established. Mere assertion is not sufficient.
Yes, what is your case? You read from your written statement.
From para 6 onwards, I think. That the suit is barred for non-vendor parties in as much as Ravindranath Chakravarti, who has admittedly 1/5 undivided share in the suit property, is a necessary party in whose absence no executable decree can be passed in favor of the plaintiff. That the statements made in para 1 to 6 of the plaint are not disputed. That the statements made in para 7 of the plaint are denied. It is however added that Sachindranath Chakravarti died leaving behind not only his widow but also one son and one daughter. That the statements made in paragraph 8 and 9 are not disputed. 10. That the statements made in para 10 of the plaint are wholly incorrect while admitting the general power of attorney was executed by Ravindranath Chakravarti, Virendranath Chakravarti, Mrs. Bhansa Chakravarti and Mahendranath Chakravarti, appointing the answering defendant as their lawful attorney in respect of their 4/5 share in the suit property. It is however denied that copies of such registered general power of attorney was handed over to the plaintiff by this answering defendant at any point of time. The aforesaid statements are mysteriously false, as neither the answering defendant ever dealt with the plaintiff regarding the suit property as an attorney holder, nor there was any occasion on the part of this answering defendant to have negotiated with the plaintiff for selling the suit property or any portion thereof to the plaintiff. The answering defendant apprehends that the plaintiff came in possession of the photocopies of the aforesaid power of attorney through some other agency, and accordingly the plaintiff came to know about the general genealogy of Vinana Chakravarti's share of his sons in the property and relinquishment made by his daughter, and has accordingly narrated these facts in the plaintiff's movie. Although the plaintiff was or is wholly unknown to the family members of late Vinana Chakravarti and of this property. That the statements made in paragraph 11 of the plaint are emphatically denied by the answering defendant as absolutely false and baseless. It is false to allege that on the basis of general power of attorney, the answering defendant approached the plaintiff for selling the suit property, and the plaintiff agreed to purchase the suit property for a total consideration of ₹40 being the highest market price. The aforesaid facts are false and baseless even to the knowledge of the plaintiff. The answering defendant states that he never had any occasion to approach the plaintiff for purchasing the said house, nor the plaintiff had any occasion to agree to buy the said house, the suit house at ₹40 lakh as falsely alleged by the plaintiff. It is submitted that in 2007 the market price of the suit building was much more than ₹1 crore, and it is absolutely false that this answering defendant agreed to sell the aforesaid property for a valued sum of ₹40 lakhs. The aforesaid statements made in para 11 is wholly false and the plaintiff is put to the strictest proof thereof. That the statements made in para 12 of the plaintiff are again false and baseless. It is denied that any memorandum of agreement was ever entered into by and between the plaintiff on one hand and this dependent on the other. On 1/6/2007 regarding sale and purchase of the suit property, there was no offer made by this dependent, nor the plaintiff had any occasion to accept such offer as falsely alleged by the plaintiff. The entire fact mentioned in para 12 regarding alleged terms of the agreement as mentioned in subpara A, B, and C are imaginary, which never existed at any point of time. The alleged agreement for sale dated 1/6/2007 is a full fact document, and the alleged signatures of the answering defendant appearing on each page of the said agreement for sale have been forged and fabricated by the plaintiff, and the answering defendant reiterates that these signatures appear in the agreement for sale. If compared with the admitted signatures of the answering defendant by a handwriting expert, the truth will come to the surface, and the entire case of the plaintiff regarding execution for sale of payment of earnest money amounting to 975,000 and alleged grant of money received by this answering defendant will be falsified. The signature appearing in the money receipt declaration has also been forged by the plaintiff, as this answering defendant never accepted any amount from the plaintiff and also did not grant any money received to the plaintiff in respect of any transaction relating to the suit property. That the statement made in 13 of the plaintiff are absolutely false and baseless. It is denied that this answering defendant ever acknowledged and admitted either the terms of the agreement or receipt alleged sum of rupees 975,000 or grant alleged money received to the plaintiff as falsely alleged by the plaintiff. As stated earlier, the alleged agreement for sale and money receipt are forged documents. In the aforesaid context, it is stated that the plea taken by the plaintiff of having paid
Primarily, everything was denied.
Furthermore, the receipt of the legal notice was also denied, and the plaintiff failed to prove the legal notice itself, which was in their possession.
They did not produce a registry receipt. They said that they sent it by registry. They did not produce it. They only just produced a copy of
Copy there. Though they claim in the IA that the originals were submitted, but I have checked the record matter, no copy with a list of documents are there in the record. In the aforesaid context, it is stated that the plea taken by the plaintiff of having paid a huge sum of rupees 975,000 by cash itself is incredible, as any famed prospective purchaser of immovable property will try to authenticate his giving by paying the advance amount by account paying check of the demand draft. The aforesaid conduct displayed by the plaintiff in that is ready paying the entire advance in cash to the answering defendant is wholly untrustworthy and indicative of falsity of his claim. That the statement made in para 14 of the plaintiff are specifically denied being completely false and baseless, as there was no transaction between the parties existed at any point of time. The question of approach made by the plaintiff in the answering defendant for receiving the balance consideration amount of rupees 30,25,000 and on avoidance of this defendant to receive the balance consideration amount with effect from 7/7/2007 does not arise at all. Therefore, the statements made in para 14 are denied and the plaintiff is required to prove the statement. That the statements made in para 15 of the plaintiff are similarly false and accordingly denied. The alleged lawyer's notice dated 27 August 2007 was never received by this defendant. If such notice was received by the defendant, a suitable reply would have been given by him to the aforesaid false claim made by the plaintiff. That in view of the argument made in preceding paragraph, the statement made in para 16 of the plaintiff are also denied. Plaintiff being a wrongdoer and having come to the court with most unclean hand is not entitled to any equitable relief sought for by him in this case. The statements made in para 17 of the plaintiff are ridiculously false and baseless. The answering defendant submits that after execution and registration of power of attorney by the four sharers, namely Ravindranath Chakravarti, Virendranath Chakravarti, Srimati Nita Chakravarti, and Ahindranath Chakravarti, the answering defendant was given peaceful possession over 4/5 share in the suit property, and therefore the allegation that this answering defendant forcibly outstayed the caretaker on 10/11/2007 is far from truth, and the plaintiff is put to the restricted proof thereof. That with regard to the statement made in para 18 of the plea, it is stated that the plaintiff is not legally entitled to get any restraint order from this.
And writing expert did not give any specific
opinion.
The plea was taken by the defendant himself that the matter, which should be sent to handwriting. Handwriting expert said that The official document of that period may be provided for ascertaining the handwriting of and the signature of that. He never produced those documents also.
Para 19 of the WS, that the answering defendant further bears to submit the positive of the case of the plaintiff will further be apparent from the fact that the answering defendant being the attorney holder has already executed and registered deed of sale in respect of foreclosed sale and received property to a bona fide purchaser.
Para number?
Para 19. A bona fide purchaser long before the alleged agreement for sale dated 1/6/2007 relied upon by the plaintiff.
Para 19.
Para 19.
Read it once again.
That the answering defendant further begs to submit that falsity of the case of the plaintiff will further be apparent from the fact that the answering defendant being the attorney holder has already executed and registered deed of sale in respect of forceful sale in this property to a bona fide purchaser long before the alleged agreement for sale dated 1/6/2007.
ना डेट है ना परचेजर का नाम है.
It has
कहाँ
come in-
date?
It has come in the evidence.
What do you mean it has come in the evidence? It should have been mentioned in the
No
written statement itself.
cross-examination has been done on that.
Need not be. Who are you? Have to prove your
But
case.
at this stage, when the property is no longer in existence, in the name of answering defendant, no relief can be granted.
It has not been proved that it is not there in you.
Well, it has been proved in the evidence.
No.
But the evidence of there were evidences on behalf of the plaintiff, and the sole defendant examined himself on his behalf manner, and those evidences are required to be based.
Let us see the impugned judgment.
Page 18.
Let us see the impugned judgment and then we'll see.
Running page 18 of the memo. Yes. I'm reading from the first paragraph.
No, your case of the
These are the
respective
facts.
parties already there. Para number 4 are the issues.
Yes, para number 4 are the issues, and para 5 would be relevant here because the witnesses have been elaborated by the. Even para 4 I am reading it.
Just a minute. What is the primary ground for refusal of specific performance?
Leadership that the power of attorney has not been brought on record. That is, even that has been taken as one of the grounds. And no issue has been framed with respect to my readiness and willingness to execute the remaining part of the contract. On that, it has been given a finding that their willingness and readiness has not been. And there is a judgment, a recent judgment, where it has been held by the Honorable Supreme Court that the issue with respect to readiness and willingness has to be framed in a specific performance act, in a case of specific performance act, and when it was not framed, the matter was again remanded to the trial court to frame a issue and thereafter to lead evidence. Now, my lord has seen the WS. Nowhere it has been objected or denied with respect to my statements that I have given with respect to readiness and willingness. A general denial of all the paragraphs with respect to the agreement, the signature over there, the money receipt has been generally been denied by me. And when it has, my readiness and willingness has not been denied, when no issues have been framed,
Which
then
paragraph specifically has not been denied? Which is your paragraph regarding readiness, willingness?
yes,
And then we will see their response to
yes.
it.
Paragraph 14 and 15. Paragraph 14 and thereafter paragraph 19.
They have not responded to this.
No, para 14 of my WS.
General
Denial.
General denial, no specific.
Even one line denial is sufficient.
One line.
General
Yes.
denial that he is denying the statement made there.
Yes.
Yes,
So
sir.
you have to prove your readiness and willingness. The law is also equally well said. This, at least it will not be an admission on their part. At least it cannot be taken as an admission on their part.
Fact of readiness and willingness has been mixed up with the cause of action para, which is para 19, which has also been denied.
So her case is that no decision, no specific issue has been framed with regard to readiness and willingness. But issue number 3 must be covering all these aspects of the matter.
It has, while deciding issue number 3, that readiness and willingness has been decided, but no specific issue with respect to that has been claimed. No specific denial to the same. So, whatever the plaint and the WS is there, Milord, thereafter further adducing the evidence with regard to that respect, which has not specifically been denied. And then, Milord, the court has rejected my claim on the ground that the witnesses to the agreement has not been produced by me. Ladyship, however, the persons in front, section 69 has been compliant of evidence. The persons in front of whom the agreement was executed, the person who has signed as the typist and the advocate who has identified the signature, those.
But there are witnesses to the agreement.
There are witnesses to the agreement.
Why have you not produced them?
One witness has died, my lord, and the other we produced
When?
by.
You have explained it that he
We
died.
have mentioned.
It has come in the deposition of PW Manor that one of the witnesses died, and the other witness examination in chief was filed, but he was not produced for
He
prosecution.
did not appear for cross-examination, so he was discharged. Yeah, read the information.
Yes. Para 5. If anything is missing while recording the evidence, you point out here and now. Right? If any paragraph is missing, such that we take note of it while passing our final judgment. Instead of reproducing the entire evidence, we can read these evidences, and if anything is missing from this, you just let us know that this is an important piece of oral evidence which has not been answered.
I'm reading from
PW1.
paragraph 4, the issues that have been
Yes,
raised,
yes.
and thereafter
Yes.
For proper appreciation of evidence, following issues were framed. 1. Is the suit as framed maintainable and have the plaintiff valid cause of action for it? Is the suit barred under the provision of specific Bill Act and CPC? Is the plaintiff entitled to a degree of specific performance of contract as claimed? Is the plaintiff entitled to any other relief or remorse? Para 5. The plaintiff examined the following witnesses. PW1 is the plaintiff Suresh Prasad, whose examination in chief on affidavit was submitted. The plaintiff witness submitted that he had filed the present suit for a degree of specific performance of the contract, recovery of possession as well as injunction against the defendant. It was submitted that the general power of attorney was executed in favor of defendant Suraj Kumar Madani by the legal heir of Dinanath Chakravarti, who was the original allottee of the suit property. It was submitted that the general power of attorney was retained by the defendant and the photocopies were handed over to him with respect to the suit property, by which he was in the know that Ravindranath Chakravarti, Virendranath Chakravarti, Harendranath Chakravarti and Leela Chakravarti had knowingly executed the said general power of attorney in favor of the defendant with respect to the through their 1/5 share in the suit holding. It was submitted that the defendant had approached him and offered to sell the suit property, which he accepted, and an agreement for sale for a total consideration of rupees 40 lakh was fixed between him and the defendant. It was submitted that the agreement for sale was given final shape on 1/6/2007 and was reduced in the form of written memorandum of agreement of sale on 1/6/2007, which was typed, signed by himself and defendant in presence of witnesses. It was submitted that the defendant acknowledged the receipt of a sum of rupees 9,75,000, which was paid as advance by him in pursuance of agreement for sale. It was submitted that the defendant had agreed to execute and register a sale deed within 30 days of agreement on receiving the balance amount of rupees 30,25,000. It was submitted that he awaited for the stipulated 30 days But after expiry of the stipulated period, he approached the defendant and requested several times for the execution and the registration of the sale deed after receipt of the balance consideration amount. It was submitted that the defendant started to avoid receiving of the consideration amount and refused to execute and register the sale deed in spite of his demand repeatedly. It was submitted that not only was he ready and willing to perform his part of contract, but he had performed a considerable part of it. He submitted that a legal notice was sent to the defendant on 27/8/2007, requesting him to perform his obligation by executing deed of sale after receipt of balance consideration amount. It was submitted that he was informed by the caretaker of the suit property over telephone call that on 10/11/2007, Suraj Kumar Karani along with 3-4 persons had threatened him and told him that he had purchased the suit property. It was submitted, it was during the pendency of the suit that the defendant sold the suit property in favor of MS Vinayak Homemakers. It was submitted that the defendant himself was a partner in MS Vinayak Homemaker and the suit property was also sold in favor of Srimati Sunita Sheth, wife of Sunil Kumar Sheth by means of registered sale deed bearing such and such. It was submitted that Sunita Sheth had got her name mutated in the name of MS Tata Steel and had constructed a multi-story building.
So this is the sale deed. The plaintiff is acknowledging.
2009, not prior.
No, that's right. But there is some document in connection with there is already a sale of this property. Maybe during the pendency of
During the pendency,
maybe.
It has come to the knowledge of the plaintiff that
Yes.
there is a sale of the property during the pendency.
So what is the remedy for the plaintiff under such circumstances?
Leadership, there is a judgment now, which says that no subsequent sale deed would be the subsequent sale deed after the execution of the agreement would be dependent of the outcome of the specific.
Where is that judgment?
Judgment, my lord, I had placed in one of the cases I was searching since yesterday, my lord, I am not getting, but there is a judgment. There is a judgment with that.
There is a judgment that he will be made party and he will join as a seller of the property by virtue of the order of the court.
Judgment is to the effect that agreement of sale does not confer any time.
No. Suppose there is a sale of property after the agreement, then or during the pendency of the suit, then that purchaser has to be made party in the proceedings only for the purposes of joining for executing the sale.
MS Vinayak Homemakers, he himself is the partner of MS, the defendant himself is the partner. He is the power of attorney holder. He executed a sale deed
and sold it to somebody else also
and
by a registered document.
And she is the sister of
maybe
the defendant.
Maybe who stopped you from making her party in the proceedings to join the sale deed in your favor? That is the law. You see, the subsequent sale deed need not be challenged, right? But they have to be made party so that they would join for the purposes of execution of the sale deed.
But from this point only, I just such a judgment.
No, you just can't. This is on the face of it. Where is your judgment? ये हम लोग डिसाइड हमारे पास साइट किए थे नहीं हम स्पेसिफिक परफॉर्मेंस के जजमेंट में हम इसको साइट भी किए हैं इसको कंसिडर भी किए हैं देखिए एक तो हम किए हैं इसको कंसिडर मिस्टर मेहता आपने केस में किए हैं सब्सिक्वेंट सेल डीड नहीं आपका भी तो एक था स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट उसमें किए हैं सब्सिक्वेंट सेल डीड था उसमें नंबर बताइए वो जजमेंट तो अपलोड हो गया ना सेकेंड अपील 5 of 2023
Leadership, this original suit was filed in the year 2007. The cause of action was of 2007. Now this has come in 2009.
Yes.
So the cause of action will also change. If subsequent
cause of action will not change. If during the pendency of the suit the property is transferred to somebody else, he is made party for the purposes of joining in for execution of the sale.
Second appeal 5 of 2020.
24
Yes.
ये जजमेंट आ गया ना आपके पास?
Yes.
फाइनल हो गया? नहीं हुआ? सुप्रीम कोर्ट नहीं गया अभी? आपके फेवर में था कि आपके अगेंस्ट में था? आपके फेवर में था कि आपके अगेंस्ट में था? अच्छा, अब तो नहीं। अच्छा, आई डोंट रिमेम्बर आपका, खाली हमको याद है केस में आप आते हो। 23 है ये, 24 नहीं। Anyways, आपको कोई रिलीफ बहुत मुश्किल है मैंने। That is the law. There was a dispute as to whether the subsequent sale deed is required to be challenged. The court said that that deed need not be challenged, but the subsequent purchaser should be made party in the proceedings so that he may join in for the purposes of execution of the deed.
Should this point be after
पढ़ी
This is the only point I have been searching since last night.
ये आपको मिल जाता, आराम से मिल जाता, हम आपको दे देते हैं। I will give you because we have decided it and we have uploaded it also.
On cross-examination by the plaintiff, and it was submitted that Sunita Seth had got her name mutated in the name of MS Tata's deed and had constructed a multi-story building on the same. On cross-examination of the plaintiff, he stated that his knowledge of English was on the weaker side. He has stated that suit property was in the name of Inanna Chakravarti, who had 5 sons and 3 daughters. He stated that all of them had actual shares in the suit property. However, the 3 daughters had relinquished their share in the suit property. He stated that the land was a disco leasehold land. He stated that he made an agreement with Suraj Kumar Badani, but he had not seen any sale deed with respect to the suit property in the name of Suraj Kumar Badani. He stated that he had seen the registered power of attorney executed in the name of Suraj Kumar Badani. He stated that he had not made Rabindranath Chakravarti, Virendranath Chakravarti, Rita Chakravarti and Ahindranath Chakravarti the parties to the present suit. He stated that he had not paid any of these people any money. He denied that the defendant's suggestion that the agreement dated 1/6/2007 was forged. He stated that Vinod Kumar Singh, who was a witness to the agreement, had died and he would adduce Arvind Kumar Singh as a witness. PW2 is Sudev Chandra Manda. He was the typist. Was examination in chief on the affidavit was submitted by plaintiff witness number 2. He stated that the agreement of sale was executed between plaintiff and defendant and was typed by him. He has submitted that the plaintiff and defendant had put their signature on all the pages of the agreement in his presence and all the witnesses also had put their signatures. It was submitted that he had put his signature as a typist and advocate Shri S.S. Singh had identified all the signature on the agreement and the agreement was notarized by notary Shri Virendranath Pandey. He identified the agreement of sale dated 1/6/2007 to be typed by him. It was marked as Exhibit 1 albeit with objection by the defendants, as it was submitted that witness had not identified who the defendant was and who the witness of the agreement were. He stated that he did not remember in how many pages the agreement was. He stated that he did not maintain any register for agreement he has typed. He stated that he knew Suresh Prasad for the last 30 years and he did not remember how many kinds of documents he had typed for him. PW3, Shiv Sankar Singh was plaintiff witness number 3, who in examination in chief on affidavit submitted that the agreement for sale dated 1/6/2007 was executed between the plaintiff and the defendant and was typed by Sudev Chandra Mandan. He reiterated what was submitted in the examination in chief on affidavit of plaintiff witness number 2. He also identified his signature on all the pages and submitted he as an advocate had identified all the signatures in the agreement. Therefore, the signature of the plaintiff and defendant were marked as exhibit on each page. On cross-examination on behalf of the defendant, he stated that agreement was typed in 3-4 pages, but he did not remember the exact page number of the agreement. He stated that he knew Suresh Prasad personally and that the person who had come along with Suresh Prasad introduced himself as Suraj Badani. He stated that he had not seen any identification document of Suraj Badani, but even though he had asked for one, The witness submitted that he knew Suraj Badani because he used to frequent advocate Ravindranath place. PW4 Hargovind Das, who is an examination chief on affidavit, submitted that the money receipt dated 1/6/2007 was executed by the defendant in the favor of the plaintiff and was typed by Sudhir Janamanda in his presence. So he is the witness to the money receipt. And advocate and the same person, PW2, has typed the money receipt as well as the agreement. It was submitted that after typing, the defendant had put his signature and he identified the money receipt dated 1/6/2007, which was marked as Exhibit 3 with the objection by the defendants. On cross-examination, on behalf of the defendant, he stated that he was Deepak Das, Advocate Clerk 6/2000, and that Suresh Prasad had got the money receipt typed. He stated that he had seen the money receipt after the filing of the case and the same was signed by Suresh Kumar Badani. Arvind Kumar Singh and Vinod Kumar Singh, he stated that he had not seen any monetary transaction happen in his presence and there is only one place in which Suresh Badani's signature appears on the money receipt.
PW2 has not mentioned about the money receipt.
No, PW2
He has only mentioned about the agreement.
Yes.
But PW4 is deposing that money receipt was signed, was typed by PW2.
Yes. And there is signature of PW2 in the money receipt also.
PW2's signature, who would exhibit? Who would exhibit when PW2 himself is appearing? Why didn't he say so? He has not stated anything regarding the money receipt.
I'm just going to because deposition is not please just go. The plaintiff adduced the following documents which were marked as exhibit. Exhibit 1. The agreement for sale dated 1/6/2007 marked with objection of the defendant. Exhibit 2 is the report of handwriting expert. Exhibit 1/1 to 1/5 are signature of identifiers SS Singh on each page of the agreement of sale. Exhibit 1/6 to 1/10 are the signatures of the plaintiff Suresh Prasad on each page of agreement of sale. Exhibit 1/11 to 1/15 are the signature of defendant Suresh Badani on each page of agreement of sale with objection. Exhibit 3 is the money receipt dated 1/6/2007 marked with objection. The defendant examined the witness. DW1, the defendant examined a single witness, namely Suraj Kumar Badani, the defendant himself, who stated that the plaintiff had no legal right to the relief claimed by him because the agreement was forged and fabricated. It was submitted that the plaintiff had no knowledge that Sachindra Nath Chakravarti died and left behind only his widow, Srimati Leeta Chakravarti, but also one son and one daughter, which shows his lack of knowledge with respect of the co-sharers of the suit. It was submitted that the plaintiff was never handed over any copies of general power of attorney and had obtained the same through some other agencies. It was submitted that he had never approached the plaintiff for sale of the suit property. It was submitted that the market price of the suit property was much more than 1 crore in the year 2007 and therefore there is no question of him offering for sale of the same for sum of rupees 40 lakh as has been pleaded by the plaintiff. It was submitted that he had neither entered into the memorandum of agreement with the plaintiff on 1/6/2007 nor had received any advance amount from the plaintiff. It was submitted that the plaintiff has also not mentioned as to what more the huge amount of rupees 9,75,000 was paid to him. It was submitted that he never received any DAR notice dated 27 in 2007 for if he had received, he would have given suitable reply to it. He denied ousting the caretaker of the suit property on 10/11/2007. It was submitted that he had already entered into a deed of sale with the bona fide purchaser on 17/5/2005 and handed over the peaceful possession of the suit property to them. It was submitted that it was much before the alleged agreement dated 1/6/2007. A cross-examination by the plaintiff. He is talking only about 2005 sale deed edition, though no sale deed has been mentioned. On cross-examination by the plaintiff, he stated that the examination in chief on affidavit was made on the basis of what he had submitted. He stated that he did not know what documents were submitted by the plaintiff. He stated that he had not read the claim of the plaintiff but knew what was written on it through court. He stated that his advocate told him what was written in his WS. he stated that he had three sisters, Sunita Badani, Sarita Badani and Mamta Badani, and Sunita was married to Sunil Kumar Singh. He stated that he had made the power of attorney with Ravindranath Chakravarti, Virendranath Chakravarti, Sachindranath Chakravarti, Leela Chakravarti. He stated that he did not know if all of them are alive. He stated that power of attorney was made in Kolkata. He stated that Ravindranath Chakravarti was in Jamshedpur, while other three were in Kolkata. He stated that power of attorney was made in the registry office Kolkata. He stated that Ravindranath Chakravarti had 6 brothers, out of whom one died issueless, whereas he had power of attorney of 4 brothers. He stated that he did not remember name of the brother whose power he did not have. He stated that he had a real estate business in Meshpur and that the Badani Trade Center belonged to his family. He stated that he had filed a GR case number 1049 of 2008 against the plaintiff, in which he had got anticipatory bail. He stated that he had sold the property on 17/5/2005 and which he had by way of power of attorney of Vinayak Postmaker. He stated that because he had the power of attorney, he had executed the sale. He stated that he was the partner of the company named Karishma and that Suresh Prasad had told him of the company. He stated that Suresh Prasad, Monukul Chandran Thakur and he were partners in Karishma. He stated that Akhilesh Kumar Katiyan and Kanchan Katiyan were relatives of Monopol. He stated that the company had taken a loan from UCO Bank and had no case had been filed against him by UCO Bank. He denied the plaintiff's suggestion of UCO Bank having instituted a case against all the partners of Karishma. He stated that Sujit Kumar Badani was a witness to the power of attorney executed in Kolkata. He stated that he did not remember if Shankar Vardhan was a witness to the power of attorney. He denied his signature on the agreement dated 1/6/2007 on the money receipt. He stated that the plaintiff had not made any payment to him by way of check, draft or cash. Findings. Issue number 3. Is the plaintiff entitled to a degree of specific performance of contract as named? Issue number 3 is taken up first for consideration since it is the principal issue in contention between the plaintiff and the defendant. Section 10 of the specific relief.
These are all quotations. When you come to Supreme Court. Then he gives the ingredients.
Yes.
At the bottom, page 34.
Hence, the relief sought is automatic. Is not automatic as court is required. After explaining 16C and
That's right.
then Supreme Court decision
Yes. Then at the bottom.
whether there exists. I'm reading from Supreme Court decision.
Yes.
The Supreme Court in its decision in Kamal Kumar versus Premlata Joshi and others in such and such. It is central principle of law that the grant of relief of specific performance is discretionary and equitable relief. The material questions which are required to be gone into for grant of relief of specific performance are whether there exists a valid and concluded contract between the parties for sale purchase of the suit property, whether the plaintiff has been ready and willing to perform his part of contract and whether he is ready and still ready and willing to perform his part as mentioned in the contract, whether the plaintiff has in fact performed this part of the contract and if so, how, to what extent and in what manner he performed and whether such performance was in conformity with the terms of the contract, whether it will be equitable to grant the relief of specific performance of the plaintiff against the defendant in relation to suit property or it will cause any kind of hardship to the defendant and if so, how and in what manner and the extent is if such relief is eventually granted to the plaintiff, then lastly whether the plaintiff is entitled for grant of any other alternative relief, namely refund of earnest money etc. and if so, on what grounds. In the present case, it is the case of the plaintiff that by way of agreement of sale marked as Exhibit 1, the superstructure standing over the holding number 2 Sura such and such Jamshedpur 7075 square feet was agreed to be sold by the defendant to the plaintiff. It was submitted that the agreement for sale was entered between the plaintiff and the defendant. The signature of the plaintiff appearing on the agreement was marked as Exhibit 1/6 to 1/10 and of the defendants as Exhibit 1/11 to 1/15. It was pleaded on behalf of the plaintiff that they had signed in presence of the witness. Arvind Kumar Singh, Vinod Kumar Singh. Further, the signature of the identifier plaintiff witness number 3 was marked as Exhibit 1/1 to 1/5 on the agreement. the plaintiff has submitted that he had signed the agreement dated 1/6/2007. However, the defendant has denied the same, stating that his signature was forged on the agreement Exhibit 1 as well as money receipt Exhibit 3. However, the identifier of the agreement submitted, the defendant had signed in his presence. When he was questioned by the defendant as to whether he had checked for identification document of the person claiming himself to be Suresh Kumar Badani, he stated that he had not seen identification document even though he had asked for the same. It was submitted, this is important, no? It was submitted that he knew Suraj Badani as he had seen him frequent and advocates at an advocate's place. The name was mentioned in the deposition. Further, the opinion of the handwriting expert was also called for, wherein the specific signature of the defendant Suraj Kumar Badani was sent for comparison with the signature appearing on the document marked as Exhibit 1. However, as per the report of the handwriting expert, Exhibit 2, it was submitted that no opinion could be expressed about the authorship of the disputed signature, and it was felt that for proper opinion, official documents containing the signature of the defendant of the year 2005-10 were required so that the same could be compared with ones appearing in Exhibit 1. Hence, no definite opinion whether the signature appearing on the agreement dated 1/6/2007 was that of the defendant was given. The plaintiff in their written argument have submitted that in a case that was instituted against the defendant in plaintiff GR case number such and such by the defendant, the institution of which was admitted by the defendant in para 35 of the cross-examination, the district and sessions judge granted bail on the submission of the lawyer that the signature of the document submitted to have been forged were similar to the complaint petition filed by the defendant. However, the order of the court recording such an observation has not been brought on the record and has been submitted by the counsel for the plaintiff itself that the same was a mere submission made by him on behalf of the lawyer of the accused and not a finding of the fact recorded by the district sessions judge. Further, even the typist of the agreement who was examined as PW2 submitted that he did not remember the name of the defendant, but he stated that he had signed on the agreement. However, when questioned, he stated that he knew the plaintiff since last 30 years. Further, even the identifier of the agreement examined PW3 stated that he had not seen any identification document of the defendant and that even though he asked for the one, he did not show him any. Hence, no document on the basis of which he had identified the executor to be defendant Suraj Kumar Badani and to be the same person. Signing on the document has been brought on record. Further, when questioned, he stated that he knew the defendant because he had seen him frequent at advocate's place. However, the advocate was also not examined to show that if the defendant did indeed frequent his place so much so as to afford PW3 the basis of sufficient knowledge to identify the defendant's signature on the agreement dated 1/6/2007. Further, none of the witnesses to agreement were examined. It was submitted that the witness Vinod Kumar Singh had, whereas witness Arvind Kumar Singh was not examined. No witness familiar with the signature of witness Vinod Kumar Singh was examined. Hence, the witness in whose presence the document was submitted to have been executed by the defendant were not examined. Further, even the person who signed as an identifier on the signature on the document could not state as to on what basis he identified the defendant to be present and to have signed the agreement marked as Exhibit 1. And nothing has been brought on record to show that in usual course of things he was familiar with the signature of the defendant and therefore capable of identifying his signature on the agreement. Further, he also submitted that it was the plaintiff who had brought the defendant along and that it was him who told him that the person accompanying him was the defendant and that he had seen no identification document of the defendant. Moreover, it was submitted on behalf of the plaintiff that if it was defendant who had approached him for selling the property described in schedule of the claim, which the defendant had denied, it was pleaded by the plaintiff that when such an offer was made, he was even given custody of the
Photocopies of the
So it was on this non-joinder of necessary parties also it was dismissed.
non-joinder of the necessary parties who have given the no. The court has held that for the specific performance act, only the persons who have entered into the agreement has to be made.
Who has entered into the agreement?
Me and
Power of attorney is nobody. Power of attorney is only representing the actual owners of the property.
Yes.
So actual owners of the property are necessary parties. Power of attorney is just a hardest between the two. Ultimately, who has to execute the deed? Suppose there is a power of attorney holder and he is the holder of power of attorney with respect to a property in which the executor of power of attorney has no title. Or suppose there is a power of attorney and in the meantime the original owner of the property has also sold the property to somebody. Possible?
These have not been treated.
No. Therefore, the owners of the property were necessary parties in the suit. How do you frame a suit without the owners as party in the proceedings? Because this is one of the findings of the court. Non-joinder of necessary party is one of the findings of the court. So, in a suit where you are seeking specific performance of contract, can only the power of attorney be a party to the suit?
Ladyship, he has been given all the power to alienate the property, to look after the property. Just because some have settled in abroad, some are not in position to come to Ranchi or Jamshedpur to execute the sale. So power of attorney is there for convenience of the owner. Now, even if they execute a power of attorney to a person and still they will have to come for executing the sale deed, then what is the purpose of having a power of attorney? Just as a caretaker he will be having that. But then he will not be having any right with respect to the property. Power of attorney itself means that the owner, the right, title and interest, the person who is having that, he may not have to come in picture, he will not have to face all the difficulties and he will act in his favor. And that has been admitted by him. So even unnecessarily if you drag them, then what is the purpose of the sole power of attorney? If he would have denied that, no, I do not have power of attorney, I cannot sell the property, then the matter would have been different. Then those persons were required to be treated as a party. Now, as far as the sale deed of 2009, he has not admitted to it. He says that in 2005 only he has sold.
No, you only say that it was
I
sold
say,
in
but it has
2009.
not been substantiated, nor he
It is your evidence that it has been sold in 2009.
there is no document with respect to
It
that.
is your evidence that it has been sold in 2009. Even if you don't file your document, but it is your evidence that it has been sold to third party. You are giving the name of the third party also, to whom it has been sold.
The case of defendant is ladyship. Maybe
You
the
are the
knowledge-
plaintiff.
Yes, I am.
You have deposed that the property has been sold.
Yes.
Right? So now you cannot say that the property has not been sold. Now the consequence is now whether a fresh deed can be executed by the court without that person being a party in the proceedings. Let's admit everything in your favor. But how will the court execute the sale deed? There is no, you see, the Supreme Court says that there is no need for seeking cancellation of a subsequent sale deed. Need not. But still, the person will have to be made party so that he may join in for the purposes of execution of the sale deed, and there is more reasons for it. That particular transaction must have been for a value. Then you cannot, deprive a person of his property, and then you say that your right is gone because you are a subsequent purchaser, or maybe during the pendency. And what will happen to the consideration amount he has paid? Court will not look into that. So these equities are to be taken care of at the time of execution of the sale deed. That person might have come with some other agreement of sale. We do not know, because that is in the exclusive possession of that person. The sale deed also you have not brought on record. You have not made him a party before the court. So what kind of relief can be granted to you? You tell us. You tell us what kind of relief can be granted to you. Now, with respect to the same property, there will be two sale deeds. Who will decide? So, there was sufficient lacuna on your part. Had you not deposed, in the opening only I was saying that merely saying that it has been sold is not sufficient. Right? You have to give the details. such that the plaintiff takes appropriate action to make them party. Right? And they will have to come and say whether they are a subsequent purchaser or they are a purchaser by virtue of a previous agreement of sale. Because agreement of sale for the purposes of a specific performance of contract need not be a registered document. Need not be a registered document. Notarized or whatever any agreement of sale will be. For 53A, it has to be registered, but not for this. Then under such circumstances, the right of a third party is going to be directly affected by this. How can the court be a party to this? You get hold of that judgment. We have considered it in another case. We have considered it in another case. देखिए ना किसमें हम consider क्यों जी को पता you must be knowing. We'll resume post lunch. I think decision on that point should be sufficient for the first appeal. Or you want other points also?
So, my lord, it is already in my favor. He has deposed that his signature are forged and fabricated. He did not bring any document of that particular time period, though it has been held by the handwriting expert. Not today, may kindly.
First appeal number 149 of 2023. Heard the learned counsels appearing on behalf of the parties. The learned counsel has counsel for the parties have commenced their argument. It transpired during the course of hearing that the suit property was sold. It transpired during the course of hearing that it has come in the evidence of the plaintiff that the suit property was sold in favor of Sunita Seth, wife of Sunil Kumar Seth, by means of a registered sale deed bearing number 3124 dated 22/5/2009, and that her name was already mutated in the records of Tata Steel Limited, wherein a multi-story building has been constructed. The said sale deed was admittedly executed during the pendency of the suit. However, the plaintiff did not take any steps to make the purchaser, namely Srimati Sunita Seth, as a party to the proceedings. The learned counsel for the appellant has submitted that she would examine as to whether the subsequent purchaser, during the pendency of the suit for specific performance of contract, was at all required to be made a party in the proceedings. And place judgments with respect to this aspect of the matter. At her request, the matter is directed to be posted tomorrow for further.
It should not be next week.
नहीं देखिए, एक बार फाइल खुलने के बाद हम दूसरा फाइल खोल के कंफ्यूजन में नहीं रहना चाहते. मैडम, I'll give you the judgment also. I'll give you everything, don't worry. एक जजमेंट में हम लोग किए हैं ना कि सब्सिक्वेंट परचेजर, क्या नाम था उसका, this issue was referred to a larger bench and the larger bench has decided this issue कि subsequent purchaser का suit for specific performance के pendency में it has been sold to her. Now whether that sale deed is required to be challenged. इसमें सुप्रीम कोर्ट बोला है need not be challenged. एक जजमेंट हम लोग किए ना, need not be challenged. And the relief कैसे मिलेगा? By making that person a party in the execution of the sale deed. है ना? ये किए हम जजमेंट खोज के निकाल. क्या नाम? महाराज सिंह.
Should the third party can always file a money suit for recovery of the money.
ऐसा
Like
नहीं
a
है मैडम.
consideration amount.
रिकवरी ऑफ मनी के लिए नहीं होगा. ठीक है, तो आपको सेकेंड हाफ में दे देते हैं जजमेंट. और हम लोगों ने इसको कंसिडर भी किया है. उसके बिना हमको जहाँ तक ध्यान है आपका सूट में कोई रिलीफ नहीं मिल सकता. कल 10:30 बजे मिला है. हम लोग भी कंसिडर किया ना एक जजमेंट. आई फीस ना
Self-demolishing statement is rest I can fight, but something which has been admitted by me.
ऐसे ही होता है. उसमें it was referred to a larger bench because there was a conflict that whether the subsequent sale deed is required to be challenged or not. The earlier bench एक 1950 का या 53 का कोई जजमेंट था कि subsequent sale deed need not be challenged, and there was a judgment wherein it was held that it has to be challenged. So there was a conflict. So it was referred to a larger bench, and the larger bench held that the subsequent sale deed need not be challenged. पुराना जजमेंट इतना कहानी हमको याद है ना. 56 सुप्रीम कोर्ट हमको याद है. आप ही के केस में किए थे क्या? हाँ, आप ही के केस में कंसिडर किए थे. ये देखिए, तो ये वाला केस में होगा एसए नंबर 5 ऑफ 2023. उसमें इसको हम कंसिडर किए हैं. उसमें आपको पुराने जजमेंट्स मिल जाएगा, लार्जर बेंच का जजमेंट भी मिल जाएगा. टुमारो 10:30 in the morning फर्स्ट केस. और क्या असिस्टेंस चाहिए बताइए. What else do you? Judgment
So
में
you
भी
see
आप
that
देख लीजिए.
the time is being granted to me. I will look into the judgments that I have.
आप देख लीजिए, लंच पे देख लीजिए, उसमें वो जजमेंट्स कंसिडर्ड है. दुर्गा प्रसाद ये ठीक बोल रहे, दुर्गा ही बोल के कोई नाम.